Senhoras e senhores, bom dia. Sejam muito bem-vindos ao 8º Congresso CAM-CCBC de Arbitragem 100% online. Antes de darmos início às atividades, pedimos a atenção de todos para alguns avisos importantes. Os idiomas oficiais do nosso evento do 8º Congresso CAM-CCBC de Arbitragem são o português e o inglês, com a opção de tradução simultânea. Na página de entrada na plataforma, você poderá escolher ouvir as palestras em seu áudio original ou traduzidas. Perguntas e comentários poderão ser enviados no chat ao lado do vídeo. Não se esqueçam de visitar a nossa área de patrocinadores e networking no menu principal. Nós agradecemos patrocinadores e apoiadores institucionais do evento. Para abrir o 8º Congresso CAM-CCBC de Arbitragem, convidamos doutora Eleonora Coelho, presidente do CAM-CCBC. Bem-vinda.
Bom dia, senhoras e senhores. Sejam muito bem-vindos e bem-vindas ao 8º Congresso CAM-CCBC de Arbitragem. Inicialmente, eu gostaria de agradecer aos palestrantes que compartilharão sua vasta experiência e conhecimentos conosco, bem como aos nossos patrocinadores pelo seu contínuo e valioso apoio. Agradeço também ao brilhante time do CAM-CCBC e a todos e todas que tornaram este evento possível num formato tão inovador. Por fim, meu muito obrigada a todos e todas que nos assistem e permanecerão conectados conosco nessas 2 manhãs de evento. Orgulho por fazer parte da comunidade arbitral, sempre engajada e em busca de aprimoramento. A missão do CAM-CCBC neste congresso, nestes 2 dias, será refletir e debater sobre o hoje e o amanhã da arbitragem. Hoje, após restrições impostas pela pandemia, constatamos com orgulho que as mudanças que protagonizamos consolidaram com grande sucesso a gestão 100% eletrônica dos procedimentos, de forma segura, responsável e eficiente. De fato, a realização de reuniões e audiências remotas por diversas plataformas homologadas, acompanhadas e supervisionadas por nossos profissionais de TI e case managers extremamente qualificados, que auxiliam partes e advogados em toda a sua condução, incluindo apresentações e na gestão de documentos, são hoje uma realidade que vieram para ficar além da pandemia. Hoje, também estamos plenamente capacitados para a realização de audiências presenciais e híbridas, tendo conduzido modernizações em nossa infraestrutura e implementação de medidas e regras rigorosas em respeito aos protocolos sanitários e de distanciamento. Neste último ano, não somente mantivemos, como ampliamos nossas atividades acadêmicas virtualmente. Organizamos e participamos de mais de 40 webinars, workshops e cursos, sempre fazendo valer nosso compromisso com a diversidade de gênero, assegurando participação de, no mínimo, 30% de mulheres palestrantes nos eventos apoiados e patrocinados. E não poderia ser diferente neste congresso, no qual temos 54% de mulheres palestrantes e 22,7% de pessoas de diferentes origens étnicas e raciais. Aumentamos também o percentual de mulheres em nossa lista de árbitros, que atualmente é de 33%. Trata-se de caminho necessário que vem sendo trilhado desde 2015, quando tínhamos em nosso corpo de árbitros apenas 14% de mulheres. Seguimos igualmente firmes na adoção de outras medidas em prol da diversidade, inclusão e sustentabilidade, como a criação de comitês de diversidade, de desenvolvimento sustentável, bem como a certificação carbono zero. Outras atividades que muito nos orgulham são aquelas conduzidas pela nossa Comissão de Jovens Arbitralistas, a NewGen CAM-CCBC. A NewGen promove cursos, webinars, workshops e organizou e lançará um livro virtual que consiste em uma coletânea de artigos sobre a proteção de dados e arbitragem. Recomendo muito a leitura a todos e todas. Conduzimos igualmente diversos aprimoramentos e novidades técnicas na gestão de nossos procedimentos, com destaque para o lançamento do regulamento de arbitragem expedita. Agora, qualquer procedimento cujo valor não ultrapasse 3 milhões de reais será automaticamente expedito. Para que tais regras se apliquem, basta que a convenção de arbitragem tenha sido pactuada após 1º de fevereiro de 2021. Essas regras prevêem que um procedimento que se encerre em, no máximo, 12 meses e pode representar uma economia de 70% no valor das custas. Além disto, temos a alegria de anunciar o início da consulta pública à proposta de novo regulamento de arbitragem do CAM-CCBC. A minuta do novo regulamento é fruto do trabalho de integrantes de uma comissão de juristas especialistas, a quem muito agradeço, tendo sido revisada pela presidência, diretoria e conselho do CAM-CCBC. Foram meses de trabalho intenso que resultaram em uma proposta que incorpora a experiência acumulada pelo CAM-CCBC e novas disposições sobre integração de partes adicionais, consolidação de arbitragens, desafios de demandas oriundas ou relacionadas a mais de um contrato, designação de secretário de tribunal arbitral e o tratamento de dados pessoais. A minuta poderá ser consultada em nosso website e as sugestões apresentadas até o dia 18 de novembro. As contribuições de todos e todas serão muito bem-vindas. Como se vê, portanto, seguimos com afinco em nossa missão, sempre pautados pelas melhores práticas, sustentabilidade e diversidade, elementos que consideramos imprescindíveis para uma atuação legítima. E os frutos positivos deste trabalho são inegáveis. O número de processos instalados no CAM-CCBC entre 2019 e 2020 teve um aumento de 8,2%. E apenas no primeiro semestre de 2020 já observamos um aumento de 14,6% de arbitragens em trânsito. Registramos ainda 90% de satisfação de nossos usuários quanto à atuação do CAM-CCBC, de acordo com a nossa última pesquisa de satisfação conduzida. Este mesmo cuidado sempre é dedicado na organização do Congresso CAM-CCBC, nosso principal evento acadêmico anual. Neste ano, o Congresso será aberto pela palestra da professora que tanto admiro, Kessedjian, que tratará dos prós e contras da solução de disputas em cortes judiciais e por arbitragem. O tema desperta grande interesse para o hoje, pois retoma os fundamentos básicos e filosóficos sobre os benefícios que o Instituto da Arbitragem pode trazer a quem livremente o adota. Em seguida, teremos o primeiro painel, que procurará responder o questionamento se o inverno teria chegado para a arbitragem e se sua legitimidade estaria sendo verdadeiramente questionada. Trata-se de oportuno debate num momento em que alguns alardeiam que uma suposta crise poderia estar se abatendo à arbitragem. Estaríamos diante de críticas oportunistas e artificiais ou de questões que demandam aprimoramentos efetivos? Uma conclusão é certa. A arbitragem é instituto consolidado nacional e internacionalmente e reflete um direito essencial de todos, a escolha do método pelo qual pretendem ver seus conflitos resolvidos. Trata-se de liberdade inviolável e que será preservada em qualquer hipótese. O segundo painel cuidará da temática extremamente importante e atual, a crise e seus efeitos nos contratos, e a forma como tais questões têm sido abordadas e decididas no âmbito dos procedimentos arbitrais. No primeiro painel de amanhã, serão debatidas as principais tendências em arbitragem institucional. Como se sabe, as instituições são partícipes extremamente relevantes no aprimoramento técnico do Instituto, na implementação das melhores práticas e na autorregulação do mercado arbitral. Assim, ouvir os representantes das câmaras arbitrais permitirá que se vislumbre como poderá ser moldado o amanhã do método. O nosso último painel tratará dos impactos de plataformas como Arbitrator Intelligence e outros, especialmente quanto a questões relativas a conflitos de interesse e dever de revelação. Por fim, teremos a honra de contar com um discurso de encerramento do querido Eduardo Silva Romero, intitulado Um Sonho de Primavera, que é o que todos nós não somente esperamos, mas buscamos para o amanhã da arbitragem. Convidamos a todos e a todas para se manterem conectados durante os intervalos entre os painéis. O engajamento social e a conexão entre os participantes do Congresso é parte tradicional de nossos eventos. No contexto virtual, não poderia ser diferente. No lugar da usual troca de cartões, temos chat para conversas em nossa plataforma. Para descontração, teremos o Momento NewGen, um bate-papo entre duas gerações de arbitralistas compartilhando situações inusitadas. Por fim, embora as incertezas destes últimos 2 anos de pandemia possam ter nublado a nossa visão do que estava por vir, o caminho do trabalho sério, ético e consistente sempre nos conduzirá ao progresso. E este é o caminho que a comunidade arbitral brasileira sempre trilhou e continuará a trilhar. Juntos, somos mais fortes e melhores. Assim, tenho a honra de declarar abertos os trabalhos da 8ª edição do Congresso CAM-CCBC de Arbitragem e da 4ª São Paulo Arbitration Week. Agradeço a atenção de todos e todas e desejo um excelente congresso. Muito obrigada.
Muito bem, e assim nós damos então início às atividades do 8º Congresso CAM-CCBC. Para proferir a palestra magna de abertura do 8º Congresso CAM-CCBC de Arbitragem, nós convidamos Catherine Kessedjian, professora emérita da Universidade Panthéon Assas, Paris II, para falar sobre os prós e os contras da escolha das cortes e das convenções de arbitragem. Seja muito bem-vinda.
Well, thank you. I hope you hear me. It is a bit strange because I have no audience but myself on the screen, and I don't know who has spoken before me. So I want to thank everybody for organizing this Congress and inviting me to give the keynote speech at the very beginning of the Congress. I understand that this talk is going to be interpreted into Portuguese. So if at any point in time I'm speaking too fast for the interpreter, I hope somebody can signal to me, although I'm not sure this will be possible on this platform, and I could slow down. Now, the exact title I chose for this presentation is The Pros and Cons of Choice of Court and Arbitration Agreements. Now, a few years ago, I would have said that this topic is completely passé. It's obsolete and has no interest whatsoever. Suddenly, in the last few months, this topic has gained interest thanks to the magical revival ushered by a good colleague and friend, no less than Gary Bourne. Gary has embarked in what I could call a crusade against the 2005 Hague Convention on choice of court, going so far as advising the few states that have ratified the convention to withdraw their ratification. I won't rehearse Gary's arguments because you can read his article and you can read whatever comments that article has triggered. What I intend to do this morning is to show that for any negotiator of an international contract, you must take into consideration all the alternatives that are available to your clients and not systematically choose arbitration if the economic context and the nature of the dispute and the nature of the parties to the disputes gives you an incentive to choose another mode of dispute resolution. And so what I'm hoping to do is to put into perspective the balance of interest at stake between the choice of court, mediation, conciliation, and arbitration. And of course, taking into consideration the New York Convention and the Hague Convention of 2005. Now, before I go further in my analysis, I want to disclose, for those of you who do not know me, that I've spent 4 years of my life at the Hague Conference on Private International Law. And that is the very organization under the auspices of which the Choice of Court Convention was adopted. So for some, I may be inherently biased speaking about the Choice of Court Convention, although I don't consider myself as such, but it may be that implicitly or unconsciously, I would like to defend, quote unquote, defend some of the work of the Hague Conference. I had left the Hague Conference at the time the Choice of Court Convention has been adopted. And for those of you who know me, you know that I am not shy at criticizing work, even at institutions where I have been located. So I think I can be trusted to be as critical as necessary on those works. So what I want to do is to look at what I call the business case of the choice any drafter of international contract has to make when drafting the dispute resolution clause. And my point here will be to say that not all disputes are proper to go to arbitration. And in fact, there is a fad, there is a fashion in the past 3, 4, 5 decades to go to arbitration systematically, even for cases that are not proper for arbitration. So what I would like to discuss with you this morning is really how to make the choice and how, what are the items, the issues to put into consideration before the choice is made. I will make 4 points and will conclude. The first point has to do with the scope of what we are discussing this morning. We are discussing business-to-business contracts. So we are discussing contracts and business relations that are supposed to be between equal parties. Of course, this is not to say that even in business-to-business situations, there may not be some imbalance between the parties. I am aware of that, and this must be taken into consideration before the choice of the dispute resolution clause is made. But it is not enough as a factor to actually choose arbitration or not choose arbitration if you are in a business-to-business situation. You need to go further into the analysis of what the case is. Particularly, you need to look at the culture of the parties. Some parties are better off being before court, some parties are better off being in mediation or conciliation, and other parties are better off being in arbitration. Now, the comparison between choice of court and arbitration cannot and must not be done on a theoretical basis, on an academic level. It must be done in concrete terms. You must compare which court is available to the parties to the specific dispute you are considering and which arbitral tribunal is also available. The comparison must be done issue per issue and specific court or specific tribunal per specific tribunal. So in other words, if you are negotiating a contract between a Brazilian and a French company, you need to look at all possible choices you have, which includes a Brazilian court, a French court, a neutral court, I'll come to that in a minute, or arbitral tribunals that may be organized and formed under any of the institutions that have the possibility to host such an arbitral tribunal. So the comparison and the analysis is a bit more complex than just putting it in theoretical terms. Now, as I said earlier, there is fashion in law as there is fashion in garment or in design. And we have to be careful not to go ahead and accept any fashion in law because that may not be the best way to advise your client. So now the second point is what are the alternatives to arbitration? The first alternative, you know it very well, could be mediation and conciliation. For the sake of easiness, I will speak only of mediation because that's what most businesses do take as a dispute resolution mechanism. I'm not going to rehearse the major differences between mediation and arbitration or between mediation and court. But what you need to know is that although mediation has the power to empower parties of their own dispute instead of seeking a third-party determination and decision, it is not exactly a decision that you are getting at the end of a mediation process, even if it is successful. What you are getting at the end of a mediation process is a contract, another contract, if you will. And that contract must be enforced, and therefore, in order to be enforced, you need a court. You need to go to court again, if you will. Of course, you may tell me that with an arbitral tribunal, you get an award and the award needs to be enforced and sometimes in court. But we have evolved quite a lot in the matter. And therefore, I venture to say that with the New York Convention, an arbitration award certainly has many more chances to be enforced than a mediation contract, a mediation settlement. Now, of course, the Hague Convention of 2005 does not apply to what we call contractual mediation, i.e., the mediation that has been put in place by an agreement of the parties. What the Hague Convention of 2005 applied to is judicial settlement. And you can go to Article 12 of that convention. Judicial settlement are settlements that are brought before the court, during proceedings in court, with the effort usually of the judge, not always, but usually, or settlements that have been taken by a third party at the direction of the court, and that's what we call judicial settlement. So I'm not talking about that in this talk. What I'm talking about is mediation between parties as they agree separately to go to mediation with a different agreement. Of course, we have now the Singapore Convention. This seems to be fairly popular these days. There are ratifications that are coming in fairly regularly, and the convention is already in force. But as far as I know, there is no practice yet on the convention. It is a very new convention, and therefore we have no real practice to look at and see whether the convention is successful or not. So this is the picture of mediation. It is very good in many cases. It can be fairly rapidly put in place. The process is usually much more flexible and much more fast than arbitration or court. But it is a completely different process. And so it's very difficult to compare it with either court or arbitration. Now, the second alternative to arbitration is, of course, court. If you decide that as a priori, arbitration may not be the best solution for your client, then you need to look for court. And as I said earlier, there are several courts that could have jurisdiction on your case, apart from your agreement. Indeed, there is a very old or fairly old institution, which I call the neutral court, which has been somehow forgotten over the years because of the skyrocketing influence and success of arbitration as a means to resolve dispute. We have to go back to this institution of a neutral court because it may prove to be really interesting for parties because their case may not be a proper case for arbitration. Now, what is a neutral court? A neutral court is a court that has no link whatsoever between the contract and the country in which the court is located, or between the parties, or between the dispute and the contract and the country, where the court is located. So it's a neutral court because there is no situation that is linked with the country in which the court is located. And therefore, a little bit like an arbitral tribunal, which is not really linked with any forum, a neutral court has the advantage of having no interest in the dispute, if you will. This concept was accepted by the Cour de Cassation in France in the 1950s and accepted to consider the Court of Switzerland as a proper forum, as it was accepted and chosen by the parties, although the court in Switzerland had absolutely no link with either the parties, the contract, or the dispute. You may also remember that in some maritime matters or other types of very specific disputes, the London court could be considered also as a neutral forum. And I'm sure there are other examples that we can take. Now, I'm not saying this is the solution to all issues and to all choices, but one has to remember this is possible. And particularly at a time when you have seen the flourishing of what we call international domestic courts, meaning courts in a country which are created specifically to deal with international cases, it may be an interesting concept to revive. Now, the Hague Convention does accept the concept of neutral court. It is implicit, but it does accept the concept. Unfortunately, the negotiators of the Hague Convention, through Article 19, were actually persuaded to accept the contrary view of some countries and say that they have the right to refuse to entertain a dispute if they have been chosen by the parties but have no link with the contract or the dispute. Again, this is Article 19. Now, this is a jurisdiction provision. It has nothing to do with enforcement or recognition. So in other words, if, as you negotiate the contract, you want to take advantage of this concept of neutral court, you really have to look at whether the country in which the court you want to choose is located is accepting this concept of neutral court or not. If not, you may be faced with a refusal by the court under Article 19 of the Hague Convention to entertain your case. And that would be, of course, very bad for your client. So you have to be careful about that. So not all countries accept it. And again, countries have been allowed by Article 19 of the Hague Convention not to entertain such a case. However, if you find a country in which a neutral court is possible and will entertain your case, then the Hague Convention does not prevent the recognition and enforcement of the decision that will be taken by that neutral court. On the contrary, your decision will be put on an equal footing with all other decisions of a court chosen, and therefore you will benefit from recognition and enforcement under the convention. I think this is a very strong case for this neutral court concept. Now, my third point deals with corruption, because the thrust of Gary Bourne's criticism has been mainly targeted to corruption in the judiciary. I cannot deny that there are countries in which corruption is indeed plaguing the judiciary. But what I do not understand is why this fact, which is well known, it's a public fact, would actually be such a strong argument to trigger criticism of the Hague Convention itself. We have to remember that if a court is chosen and that court is corrupted, it has been the choice of the parties. So I am wondering how much the law can protect somebody against its own, and I'm sorry, I'm going to say something very harsh here, its own stupidity. If a party, my point is that corruption in the judiciary is so well known in some countries that I do not find plausible that parties and negotiators of a contract would have chosen a court in such a country. And therefore, I think the possibility that corruption can be in the way of a decision that can be enforceable is probably not such a strong possibility at all. Now, let's go to the extreme and consider that the choice of court has been made for a country where no corruption has been known and therefore seemed to be a safe choice. Now, I'm not denying that there may be something that could have happened during the proceedings and that corruption may have been at stake, even though this was not something publicly known before. Now, contrary to what has been said in other circles, the Hague Convention, in the same way as the New York Convention does it, gives a strong obstacle to the recognition and enforcement of such a decision taken by corruption. The Hague Convention has as a provision public policy being an obstacle for recognition and enforcement. Now, nobody denies that the fight against corruption is part of public policy. It's part of public policy almost everywhere. If we look at all the rules we have, international law rules we have against corruption, it can be said that this is a strong public policy of every single country in the world. And therefore, I do not see how the Hague Convention could be said to favor or be neutral or be actually blind to that kind of obstacle. My fourth point and last point is about enforcement. And this is the last point of comparison. Now, I invite you to look at the text of Article 9 of the Hague Convention and Article 5 of the New York Convention. You will be seeing a very large similarity in both provisions. And that's why the Hague Convention proponents have been saying that what the Hague Convention is pretending to do is the equivalent for choice of court of what the New York Convention is doing for arbitral award. And in fact, they have copied almost word for word some of the provisions of Article 5 of the New York Convention, including some that probably they should not have. The Hague Convention being a much, pretending to be a much modern convention than the New York Convention, which has been, as you all know, negotiated in the 50s. Now, in conclusion, when you negotiate a contract, what you have to do is first to look at the economy of the contract, its total value, the potential value of future dispute, who are the parties, what kind of economic position they have, what kind of culture they have. These are essential elements in order to cater for the proper provision on dispute resolution. The personality of the parties is very important. Are they sophisticated or not? Are they repeat player in international commerce or not? It is very important because in arbitration, you need to be sophisticated. You can, as a party, arbitration is not for somebody who has very little experience in that field. The kind of dispute is, of course, very important in the analysis. If it is very technical, if it is very complex, that may be a triggering factor to go to arbitration, although it may not be, because you may have courts that are specialized in the field, like, for example, in the patent field. You need to look at the applicable law. The applicable law is very important, and you all know probably that arbitral tribunals have a lot of leeway in applying the law. Therefore, if you planned your contract within the compound of a juridical system, you may be better off not going to arbitration, because perhaps the arbitral tribunal will have a different take, a different interpretation of that domestic law, as it is allowed to do. My fifth point in my conclusion is that the alternative neutral court exists. You must look for it. You must make sure that it is located in a country that accepts the concept, and therefore the court will accept to entertain your case. This is very important. The duration in each forum is actually a very important point to compare. You don't compare arbitral proceedings with French court proceedings or English court proceedings or Belgian court proceedings or Brazilian court proceedings in the same way. So you really have to look at which court is the alternative and how the timing of the proceedings will fare in comparison with arbitration. Finally, the cost of the proceedings will have to be taken into consideration, particularly in comparison with my very first point in my conclusion, which is the economic context of the contract. Some contracts are not value based enough to justify to go to arbitration. It is only after such an analysis that you will be able to actually cater for the real needs of your client. Thank you for your attention.
Nós agradecemos a professora Catherine Kessedjian pela brilhante exposição e seguimos aqui com o primeiro painel, a legitimidade da arbitragem. O inverno chegou? Convidamos a compor este painel Andrea Galhardo Palma, juíza da Segunda Vara de Direito Empresarial. Também Claudio Salas, conselheiro especial no Departamento de Litígio da Wilner Hale, Nova York. Susan Frank, professora na American University. Stavros Brekoulakis, professor e diretor da Escola de Arbitragem Internacional na Universidade Queen Mary de Londres. Atua também como árbitro. E o nosso moderador, Carlos Alberto Carmona, árbitro e professor de processo civil na Universidade de São Paulo. Sejam todos muito bem-vindos. Palavra com o moderador, Carlos Alberto Carmona.
Bom dia a todos. Good morning for everybody. Good afternoon in London and in Portugal also. This is a very international panel because every one of us is in a different place. Andrea is in Portugal, Claudio is in New York, Susan is in West Virginia, I suppose, and Stavros is in London. So not in West Virginia anymore. But this panel is going to discuss legitimacy in arbitration, and it's going to be a very interesting discussion because we have several issues that we have selected in order to make a discussion, not a lecture, but a discussion. And it's going to be very interesting because Stavros is going to make an introduction linking Gary Bourne, Game of Thrones, legitimacy, and arbitration. Very difficult to put everything together, but Stavros said that he is able to explain what we are gonna talk about. And Susan Frank is going to talk about time and cost in arbitration. And she loves investment arbitration, but she promised that she would make some considerations about commercial international arbitration because she knows that in Brazil we don't know investment arbitration and we don't use it. We are not a member of the Washington Convention. Claudio Salas is going to talk about people in arbitration. And Andrea, who is a judge here in Brazil and one of the judges responsible for business litigation and specifically arbitration litigation in the courts, is going to talk about interplay between courts and arbitration. So we are going to have time to questions from the audience, and I have in my WhatsApp. I'm expecting your questions. And first of all, Stavros, for your introduction, please. You have the floor. We can't hear you. I don't know if I can hear you or try again. No.
Carlos, can you hear me?
Yes.
Hey Claudio, you have to refresh your page. Just refresh it.
Can you hear me now?
Yes, great.
Okay. Well, I'm at least delighted that we have one least obstacle, because my main concern is that I never aspired to link Gary Bourne, Game of Thrones, and the discussion of legitimacy. Only Gary Bourne could do that. My aim today is much more modest, and what I want to do is make some general observations on the nature of the legitimacy inquiry, which my fellow panelists will then further address. But it seems to me that while we have been talking about a legitimacy crisis in international arbitration for a while now, we don't necessarily know what the concept of legitimacy means, and we do not always speak in the same terms. So drawing on scholarship on legitimacy, broader scholarship on legitimacy, I want to set the background for hopefully a more meaningful discussion on the topic. The first point I want to make is that the discussions on legitimacy in the field of international arbitration is not an outlier in the context for international law. The focus of the debates in international law has changed in the last decades. International legal scholars are currently concerned not so much with whether international law exists, as they did back in the 60s and in the 70s. And you will remember the debate about lex mercatoria and whether non-state entities could produce transnational laws. This is no more the discussion. This is no longer the discussion. International law scholars today are mainly concerned with whether international law is fair and meets certain standards of legitimacy. So it's only natural to discuss about legitimacy in international arbitration as well. The second point is not only that it is natural, but it is also the right thing to do, because perceptions and indeed evidence of legitimacy for any international legal institution is an important currency for the acceptance of and compliance with that legal institution. Unless arbitration finds a way to meaningfully engage with a wider public and demonstrate arbitration's legitimacy, including through arbitration's contribution to the wider good and society, arbitration may well face existential threats in the decades to come. I thus very well welcome the debate and the focus of the debate of the conference today. But what do we mean about legitimacy? A number of different ideas of legitimacy exist in international law and dispute resolution, but for the purposes of our session, I have identified three. The first looks at sources of legitimation through democratic processes. For every institution of international law and dispute resolution which claims and exercises legitimate authority, they have to go through a process of democratic participation and effective representation. For example, judges in national and international courts are either appointed by state authorities, which themselves have legitimacy through democratic processes, or in some jurisdictions, judges are elected directly through democratic processes themselves. International tribunals clearly claim and exercise authority to review and decide disputes of hundreds of millions or sometimes billions of dollars. But however, the questions in relation to their democratic processes arise. How do they get selected? Who are they accountable to? How transparent is their operation? And what are the process of the democratic foundations of their authority in the first place? More specific questions arise for arbitration in relation to questions of diversity and their representation to arbitral tribunals. And this aspect of legitimacy, especially focusing on diversity and the demographics of the people participating in international arbitration, will be addressed by Claudio. The second idea of legitimacy draws on a Roselian idea of procedural justice. To be legitimate, institutions of international law and dispute resolution in particular needs to meet certain standards of procedural justice and efficiency. For roles, legitimacy is linked to compliance through procedural justice. The main justification here of legitimacy is that disputing parties will comply with a decision of an arbitral tribunal only if they are convinced that the decision has been the product of a fair and right process. In this regard, the dispute resolution paradigm of international arbitration has been often criticized as being procedurally unfit. And there's specifically 3 points of criticism here. The first is that international arbitration is perceived as lacking rigorous evidentiary and decision-making processes. Typical examples here is the critics say is the lack of a rigorous process of discovery for the taking of evidence, and importantly, the lack of an appeal process. The second accusation relating to procedural legitimacy is that because arbitration is a system of ad hoc and party-appointed arbitrators, international arbitration accounts for a dispute resolution system which is inherently biased in favor of the stronger commercial parties and repeat users of the system. How can a tribunal not be influenced, the argument goes here, when one of the parties is a big successful corporation in the construction industry or the oil and gas industry, which regularly resorts to arbitration, uses arbitration, and has dozens of arbitrations across the world every year. These big successful corporations and their law firms, the accusation goes, can sustain arbitrators' income, and therefore surely arbitrators do have in mind this consideration when they will take the final decision. The third accusation of legitimacy on process goes to the lack of procedural efficiency rather than rigor and structural bias. And here it is an accusation which concerns that excessive, as the criticism goes, time and costs associated with the resolution of commercial and investment dispute. How can you have a legitimate system, the accusation goes, when one party, which may be a party with limited financial resources, is needed to pay extraordinary amount of money to get access to justice and represent itself? Susan is going to address this point, and I will say no more. The final idea of legitimacy, which matters for international arbitration, goes not to the democratic processes or procedural justice, but it raises an important question of substantive law, namely the risk that parties involved in a commercial arbitration or a commercial transaction may structure their arbitration in a way that can avoid the application of important mandatory rules and the public policies of states which have a clear interest in the dispute. This is the typical Mitsubishi and Solar factual scenario where two parties agree to arbitrate their dispute in Japan and the Swiss law in order to avoid the application of US, for example, antitrust or environmental laws, even though the contract which the dispute arises from is a contract to be performed in the United States, and it's clearly linked to fundamental public policies in that state. In such a case, a tribunal sitting in Japan will have no direct obligation to apply the US antitrust rules, not least because there's no international treaty that exists that would oblige arbitrators to give effect to the overriding mandatory policies of that country. So the ability of parties to structure the substantive makeup of their dispute in a way that can avoid mandatory rules and public policies, together with a limited review of international awards by national courts, has given rise to accusations of legitimacy on the basis that international arbitration allows commercial corporations to operate in the shadow of the law. This aspect, and especially the interplay between courts and arbitration and the review of arbitral awards by national courts, will be addressed by Andrea. So this is, in broad terms, the context of our discussion for legitimacy, which I hope will assist our panelists to further discuss aspects of the legitimacy debate and also assist the audience to understand where this apparent legitimacy crisis in arbitration comes from currently.
Thanks, Stavros. Very, very good. I have a doubt. When you talk about procedural legitimacy, perhaps today, with artificial intelligence, for instance, we are going to change this concept of legitimacy because perhaps we're going to introduce an imbalance in this scenario, isn't it? For instance, an arbitrator can use some programs of artificial intelligence. If I am an arbitrator and I do not tell the parties I'm using this kind of program, is it legitimate to use this program without telling the parties I'm doing this? And think about the lawyers. If I am a rich lawyer and of course, if my office is good enough to pay for a program, I'm gonna use it, and the other party will not have access to the same product. Think about international arbitration between an English industry and a poor African party. So the imbalance is going to be worse, isn't it? What's going to happen?
Carlos, are you asking me?
Yes, sure. Because you mentioned this procedural legitimacy, and I would like to explore this. Yeah.
I think these are all very valid points that you make there. The first point I want to make is that techniques to somehow gauge the way that decision makers will decide, will go, have existed, especially in the context of US national litigation for many years, from the 60s and the 70s. The very well-known and established law firms there have always tried to team up with professors of international psychology, and they have developed techniques to somehow decide where the jury would go in the decision. I'm not sure whether there has been any issue in relation to due process that has been raised in the context of US litigation. But I can see the argument here in international arbitration. In London, there are firms and corporations that provide their services about that. They claim that they have the techniques and they have the software to somehow find out how Carlos Alberto Carmona will decide if he is appointed in an arbitration. What is his previous decisions? To what extent he feels some arguments more sympathetic towards others? And there is a concern to what extent this kind of ammunition is available only to one party over the other. Whether, again, this goes to the heart of procedural justice, to the heart of due process, I don't know. But it's certainly something that we need to keep an eye on. And I can see the argument from one party, a weakened party, saying, I just don't have the same kind of information. I just don't have the same kind of means to address important processes in international arbitration. It is too early to say, but I can only say that this is a very, very valid point, Carlos.
Thank you, Stavros.
I would like to chime in, if I may. I'd like to point out two things. Everything old is new again. The issues of equality of arms and access to justice have been with us since time immemorial. Technology is just the latest iteration of this. And I would say, as someone who loves technology, statistics, and data, I would commend to all of you the new book by Daniel Kahneman, which I just grabbed, called Noise. And what it looks at is decision makers in legal institutions and how difficult it is to predict even with AI. One of the core conclusions is, especially when you have limited data pools like international arbitrators, simple models are best. And they're far more, shall we say, useful and efficient in making predictions. So to the extent I think we're a bit early in the game of understanding how AI can or cannot be outcome determinative, I would just add a note of caution and include an opportunity for you guys to read the new Kahneman book because it is fascinating.
Okay, and now it's your turn, Susan. Perhaps you can talk about impecuniosity also, because this is a problem also. You don't have to you don't have how to pay the lawyer, the procedure, the chamber, the center of arbitration, and this AI programs. So impecuniosity is going to be the next the next winter. Who knows? Tell us about time and cost.
We shall see.
Yeah.
Well, I wanted to thank the conference organizers for inviting me to present to this group and also to be able to present with this august panel. I've been thinking about legitimacy issues for over 20 years. And I brought them up in my first article in 2005, hence why I say everything old is new again. And the issues that we face today are nearly identical. Yes, there are wrinkles on the margins given changing technology and geopolitics, but the core is fundamentally the same. And as Stavros indicated, one of those core questions is time and cost. I first became interested in those points as a practitioner, whether it was counseling clients in the United States or as a solicitor in England and Wales. The favorite question of my clients was, how long will it take and how much will it cost? Clients need answers to those questions, as it's all about the relative value of dispute resolution generally and arbitration in particular. And this picks up on some of the themes from Professor Kessedjian's talk. In an era of pandemics and challenges with global supply chains, the return on investment from dispute resolution is fundamental. People need to know what they get at the end of the day and whether it's worth the physical cost, the stress, the expenditure of personal political capital, to say nothing of the impact on clients. This means time and cost affects the relative efficiency of international arbitration, but not necessarily legitimacy. When choosing international commercial arbitration, stakeholders know ex ante they are contracting for a lack of appellate review to correct for legal error. Commercial arbitration sacrifices with intentionality a guarantee of legal correctness for process control, procedures tailor-made for disputes, streamlined enforcement, adjudicator choice, and the likelihood that procedural safeguards will generate a proper outcome. Which brings me back to time and cost and whether or not the trade-off is worth it. If I understand the Portuguese correctly, because I only know the Spanish, vale a pena. To the extent that parties contract for dispute resolution and have expectations about that process, deviations require both the consideration of arbitration's relative worth and the management of client expectations. Research from the Chartered Institute of Arbitrators suggests that clients in commercial arbitration expect tribunals to render awards in 6 months. This, however, can vary considerably from the reality of dispute settlement. Case completion is also not the same as deliberative delay. There can be gaps between when the final hearing is done and the rendering of the award. Even at the LCIA, with a primarily commercial caseload and public data, their average time from hearing to award is 3 months, whereas in the data I analyze, which focuses on ICSID, SCC, the Stockholm Chamber of Commerce, and ad hoc arbitration, deliberative delay was 10 months from the date of final hearing to an award. To get a better handle on reality and its nuance and prevent expectations from being mismanaged, better empirical data about case length and cost must be available for research. Not only would this aid clients and counsel, it would create transparency to aid arbitration's public relations problem and permit assessment of arbitration's relative advantages. I'd like to offer a perspective using some data from my own book, Arbitration Costs, which focuses on treaty disputes. So keep this in mind. It's not commercial arbitration and inferences are limited because the disputes are between private parties in commercial arbitration and don't have states and typically then lack the political implications, which might skew towards a case being more costly and longer. Nevertheless, given that treaty arbitration is the tail wagging the dog, this baseline offers a critical perspective. My data suggests that the average time to resolve an investment treaty case from the time it's filed until the final award is between 3.5 to 4 years. Compare this to the average rate of dispute resolution in some national courts, which is maybe 1 to 3 years, or to say nothing of other jurisdictions where the time may be 20 years. But it's not just the time, it's the cost. My data reflects that the total cost of investment treaty arbitration are between, on average, 11 to $12 million United States. That is large, and it is just the legal and administrative costs, not damages. For claimant counsel, the average amount is about 5 to 6 million per case. For respondents' lawyers, the average cost is around 4 to 5 million per case. For the tribunal, institution, and related administrative expenses, the average cost is roughly 1 million. And you can compare this to some data that came out from the LCIA that said they were under 400,000 in their commercial caseload. But I'm not the only one who has identified numbers in those ranges. There has been replication by others using different data and methods, including Jeffrey Commission. Now I'd like to connect time and cost. Benjamin Franklin was famous for saying, time is money. My research suggests that conventional wisdom is indeed wise. I found a reliable statistical relationship between time and cost, and that has several embedded conclusions. As the number of months it takes to resolve the case increases, so does the cost of claimant lawyer. As the number of months it takes to resolve a case increases, so does respondents' costs increase. And likewise, with the increase in the number of months, so too go up the tribunal and administrative expenses. And likewise, when there's a down on the time, there's a down on the cost. Of all the different types of variables that I explored in my research, and I'm telling you there were over 500, it was pretty big, case length was the only variable that reliably predicted every single type of arbitration cost. I could talk for a bit about these findings and others in my book and what that might mean for arbitration's relative value. But what is important is time and cost are the sting in the tail, and they create a great deal to talk about. So I hope this preliminary frame sets up a robust basis for conversation with my co-panelists.
Thank you, Susan. Well, I have lots of questions, and I would like to make some of them, if you allow me. When parties have this, they think about the duration of arbitration, and they have this expectation of 5 months. It's interesting because when we organize the procedure, they ask for 60 days to present their state of claims and state of defense. So it's interesting. They think the arbitrators are slow, but they want a procedure that permits to the lawyers to write hundreds of pages, which is incongruent. But I would like to listen something about the experts and about something that is very common in our civil law countries, which is the legal opinions. This increases the cost of arbitration. Experts and legal opinions. How to deal with this problem? Because expertise today, at least in Brazil, is costing a lot of money. So parties will pay much more to the experts than they are going to pay to the arbitrators. So the cost involved in arbitration is mostly expertise. I don't know if in the United States we have the same problem, but here in Brazil, it is a real problem. And the second point is legal opinions. What do you, from the perspective of common law, how do you see the importance of this legal opinions that we use in civil law countries?
Well, I think I'll focus on the. Oh, Claudio, go.
Sorry, I was just going to say that from a common law perspective, I've been surprised by the number of legal opinions. Usually, experts are in technical experts and damages experts, but the arbitrators are supposed to know the law. And so the proliferation of legal opinions, I think, has, to me, been surprising in the practice in Brazil. And not only that it's legal opinions, but also a large number of them. And so you may have 3 or 4 legal opinions on what seem to be similar topics. And so I don't know, maybe throwing the question back to you, Carlos, is this is kind of culturally expected that it is valuable to get many different perspectives from experts, and that is both in the litigation context in Brazil and in the arbitration. And so it's a kind of part of the cultural aspect, or if there is something else going on.
Yeah, it's interesting because in common law countries, for instance, they consider a professor who is going to prepare a legal opinion as part of the team. And here in Brazil, we don't see this professor who is going to prepare this legal opinion as part of the team, as a lawyer to the parties. He is completely independent. And I don't know if an American, for instance, can understand this position and the importance of an independent legal opinion. Or if an American arbitrator, for instance, understands that he is dealing with an independent guy, not a member of the team. So it sounds awkward from my perspective. It sounds awkward from a British lawyer, for an American lawyer, to have this kind of independent opinion. What kind of independence is this? So you are hiring this guy, and he is going to present your thesis, but we consider it independent. In France, for instance, they cannot understand this kind of independence. What kind of work is this legal opinion? And we are used to these opinions in Brazil. I don't know the rest of South America, for instance, or Central America, if it is more or less the same. But I see that in Brazil, in Peru, in Chile, in Argentina, it's common to have this kind of legal opinion as part of the procedure, and it involves cost. And at the end of the day, you have to discuss with the parties if you are going to consider this as part of the cost, and you are going to divide the costs, to split the costs depending on the result of the arbitration, or it is your choice, so it's not part of the cost. So you don't have to keep into consideration this kind of costs in arbitration. This is why I would like to discuss with you this point of view. And I don't know if Susan or Stavros have different opinions about this.
Well, I
Susan, do you want to go first?
I'll take it. I think, to me, the bigger point is it shows how important the culture map is with the assumptions that we bring to dispute resolution and how focused those are from where we receive our primary legal training. To me, opinions are a fixed cost. And I think Claudio alluded to this when he said it is, it doesn't matter if you're in court or in arbitration. If you need an expert, you have an expert and you must pay for it. So there is that element. But nevertheless, I think that there is also different cultural expectations about what people think experts should be. For example, in the United States, they think that perhaps they're more partisan, maybe a little bit in England and Wales, but not necessarily. And let's not forget, in international arbitration, tribunals always have the power to appoint their own neutral expert. So to the extent there's an expert opinion that is required, there is authority on the parties, on the tribunal's behalf to do these sorts of things. And then that just becomes part of the tribunal's administrative expenses that will ultimately get picked up by the parties according to the cost shifting the tribunal uses or doesn't use.
Good. Stavros?
Yeah, Carlos, I want to make 3 points following up on this question. The first is that it's one question as to whether legal expert opinion is costly or is partial or impartial. Another thing, whether it is necessary. And in my view, in the context of international arbitration, I've never found legal expert opinions very useful. I think the point can very helpfully be pleaded by counsel We're all lawyers. We understand the importance of the law. We have understandings both from common law and civil law legislation. And I don't think that lengthy legal opinions from professors, and I'm saying that with all due respect to my fellow professors, are always helpful. But this is a distinction to draw between legal experts and technical experts, including expertise in delay and quantum, which I find very helpful. Yes, there is a long discussion in international arbitration as to whether they are experts in technical matters are higher guns. But within the perspective that obviously an expert will present their views in a light that favors the party who appointed them, I would always find them helpful because they have a much better understanding about construction disputes, about how delay is linked with important construction phases, which the tribunal will never be able to understand. And in relation, the third point I want to make is in relation to the party appointed expert as opposed to a tribunal appointed expert, which Susan made. I understand the point that the tribunal has the power to appoint their own experts. I've always found them an additional element for complexity and further costs, because when the tribunal decides to appoint one expert, then obviously the report of the tribunal appointed expert will have to be submitted to the parties. And the practice of the parties is at that point of time to produce their own additional expert to make comments on the expert produced by the expert appointed by the tribunal. And then you end up with 3 different expert reports. And then there are many issues that complicate costs and time. So yes, the system of party appointed experts, and I'm not talking about legal experts, but about experts in construction disputes merely, it's not perfect, but I think that somehow in practice.
Good. And Susan, I would like to come back to another argument of yours about the state in arbitration. You know, we are talking about commercial arbitration, but in Brazil and in Portugal also it happened. The state is involved in arbitrations, in commercial arbitrations. And why does it occur? Because in some countries, especially in South America and Central America, take part in the commercial activity. It creates some companies that are owned by the government, and it is the government in litigation. So this is a new phenomenon. We are not talking about investment arbitration, where you have the state against the private party, but you are talking about commercial arbitration, and you have the state against the party, against a private party. It doesn't happen in the United States. As far as I know, it's not common to have the state involved in arbitrations, but it's becoming more and more common in Brazil, in Peru, in Chile, in Argentina, in the southern part of the country, in Mercosur in general. So how do you see this participation of the state, but in the commercial arbitration and not in investment arbitration?
Well, I think that from my perspective, it's very important to remember always the applicable law. If it's the treaty arbitration, it's the treaty arbitration with the treaties providing the applicable law. When it's commercial arbitration, when you need to buy a turbine or you need to actually pay for the electricity in a government building, those, as you indicated, Carlos, that's more of a commercial participant. So what I would flag to you is even in the United States, there are opportunities for governments to sue and be sued. And that is often a function of I've got a commercial contract and that is what I need to enforce. So I haven't seen governments going to arbitration to resolve private disputes if they're a core public entity, but I would anticipate that there may be agencies or instrumentalities operating in the commercial sphere that would actually choose arbitration. So that's the first stop shop. The second is it is really difficult to find high quality data in connection with investor state disputes that occur on the basis of commercial law with the applicable law. I find people conflate the two all the time, so my ability to speak with clarity is undermined. However, my knowledge and of what's going on the inside suggests that even when you're dealing with a state, people end up giving states discounts. So if you look at it in the treaty context very briefly, you will see there's a little bit, it's not statistically significant, but there's a little bit of variation between what states are able to get their lawyers to do. And they usually get a nice discount, right? Because there's something about knowing a state is a state. It is a repeat player. You want to keep that relationship going, to say nothing of other people may be willing to give lower rates. And then you have a race to the bottom in terms of the cost to represent government. So states may pay less, but lawyers may make less representing them. That is my gut, irrespective of whether or not it is treaty or commercial arbitration. But again, the data I don't have, and I wish that I did.
And Claudio, what about you? Do you have any thoughts about this participation of the state in commercial arbitration? Because I know you have experience in South America in general and in Brazil specifically. So how do you see this participation of the state in arbitration? Because the huge arbitrations here in Brazil are, well, the state is present.
Yeah, I wonder if the participation of the state just brings a spotlight to arbitration. I think of the legitimacy questions that we've been discussing arise first in investor-state arbitrations, and they get really highlighted, even though it's a minority of arbitrations. That's what gets all the attention. And I wonder if that will bleed into commercial arbitration in which there are state participants. So, for example, I think in investor-state arbitration in Europe, with ECMIA, there's been a jealousy of the ECJ and who gets to decide European law. You know, I wonder if potentially in Brazil, there might come a point in which state entities don't do so well in these arbitrations, and there might be a question of the legitimacy of commercial arbitration and perhaps a backlash into whether really it should be state courts should be deciding this disputes in a transparent way. And so I wonder for the future how that spotlight of having a lot of state participants in commercial arbitration will affect legitimacy questions and how arbitration is viewed by the public at large.
We have a specific question here in Brazil about legitimacy because the state will not pay in advance the costs of the arbitration. It's different from investment arbitration. Everybody is going to pay for the arbitration. But here in Brazil, no, the state is not going to pay anything in advance. So the private party is going to pay everything in advance, and the balance in the arbitration is going to be changed. Susan.
Interesting empirical research that's from the United States. Namely, when there are state actors involved in dispute settlement, they tend to do better than private actors in outcome. Mind you, it's the United States, it's litigation, but it's been fascinating to be able to look at some of those elements and see, wow, why is it that states are faring better in U.S. domestic litigation than private litigants? So I just put that in the back of your head, and then the question is, does it translate to Brazil?
Okay. I have a question. Well, it's not my question. It's a question of Regina Stanopoulos. She has a question to you, to Susan. Okay, time is money. How do we reduce both then?
I think that is the $1 million question. But I would go back to client expectation. People say they want a Ferrari, but they only want to pay for a Honda. So part of the problem is trying to work through what people really want to make sure you can manage their expectations. There's also a difference between what people say they want at the beginning and what they actually need or they're willing to do in terms of strategy. So people say, I want it cheap, I want it fast, all those things. But then they want rounds and rounds of briefing, or as Stavros alluded to, lots and lots of experts. And so there's this contradiction between what people say they want and then what they do with the procedure. I know many arbitrators who are desperate to get expedited procedures in because they think, given the amount in controversy, that is warranted. But yet the parties can kick and drag their heels. So it's a challenging balance as an arbitrator to get these kind of ducks in a row with time and cost, but it helps tremendously if you've got the parties who are on board and no one will be benefited per se by delay, because then maybe people just need a quick solution or a quick resolution. Then with if everyone is on the same hymn sheet, it's much easier to decrease time and costs, or consider expedited arbitration rules for a particular dispute that may have arisen. That can help, but you will get a little bit more rough justice. But if that is what you need and that is what you are paying for, then that is what you can have.
I have a comment here from Marcel Innocenti. He says that, I believe that the expert work is fundamental to solve some issues that are beyond the scope of lawyers and court authorities. The cost of the expertise must be proportional to the value of the demand, since an expert view can help resolve a dispute involving technical parameters and large amounts in a fair and balanced manner. So I think Marcel Innocenti is an expert. I'm not sure, but I think that I think it is too expensive. From my point of view, there is an exaggeration in the costs of the expertise. Stavros, please.
Yeah, thanks, Carlos. A very brief point, I think, because following on the good points that Susan made and Claudio made, I think we need also to put in context what exactly we mean by arbitration being too costly and too long. Because, okay, forget the investment treaty arbitration, which is, as Susan said, the average is 3.5, 4 years. But construction arbitration, which is very complex and requires proper examination of a large amount of evidence, large number of submissions, expertise, documents, delay expertise, to get it within 2 and 2.5 years, I don't think it is a necessarily prolonged process. And if we're talking about disputes that are worth of close to $1 billion, of course the parties, we will not leave any stone unturned in terms of legal submissions, in terms of factual evidence and expertise. But any delay, if you call it like that, in the form of 2.5 years, I don't think it's unnecessary or unreasonable. It is the nature of the complexity of the disputes in contemporary business transactions that I think requires very careful consideration, very careful examination of the evidence and the factual circumstances surrounding a dispute. So I think it is important to keep in mind the context and the broader perspective of what exactly do we mean? What are the expectations for quick resolution? Susan also mentioned the good point about expedited arbitration. Will the parties be happy to trust $1 million dispute, a very complex dispute, in expedited procedure of 6 months? I just seriously thought about that.
Never. You're right. Yeah. Susan?
I want to make a quick comment, but I'm conscious of the time that we have as well. I think when I sit as an arbitrator, for me, it's all about PO1, procedural order number 1, making sure that there are clear timetables, and then also what does not necessarily happen in many cases, clear cost implications when there are violations of that procedural timetable. There can be good reasons for it, but at the same time, get everybody on the same page and be clear about the implications of delay, and then make sure that the tribunal is working together to diminish any delay between when the final hearing is and when the award is rendered. It's actually shocking to me that it's 10 months on average in treaty cases between the last hearing, even for a jurisdictional award, to get an award on that dispositive issue.
Claudio?
Yeah, I had one sort of last point, which is, yes, commercial arbitration may be slow and may be expensive, but in comparison to what? So what is the alternative? And what I wish I had data on, and I don't know, maybe if Susan has it, is how long and how expensive is court litigation? My feeling in the US with discovery, that it could be quite more expensive, but unfortunately I don't have the data and I wish I did.
yeah, it's something different in South America in general, because we don't have discovery, and discovery is something very very worrying in the common law procedure. Andrea, you were very quiet. Do you want to contribute with something about this discussion about arbitration?
Well, sorry, because I still have a jet lag in Lisbon. I just arrived in Lisbon, but in my view, I think arbitration is match with the transaction and commercial market. It's perfect. It's perfect to that. In Brazil, I think we have some problems because arbitration is I think it's a teenager in Brazil, but I think it's the best way to decide to resolve a dispute, commercial dispute, and also investment dispute. And regarding legitimacy, I think I have a broad concept, maybe because I'm a judge, regarding legitimacy. But I really like the view of Professor Stavros regarding procedural justice in arbitration, international arbitration, and also domestic arbitration. And for judges, it is very important because this interplay, we want to feel that arbitral community knows perfectly what does it mean legitimacy in domestic arbitration or international commercial arbitration. For judges, the legitimacy is a matter of law, but in arbitration it's a matter of the contract. And also there is some categories, ethical categories, and that can refer to legitimacy also. I will address a little bit when I have the opportunity to discuss about legitimacy and that interplay between courts. And for me, it's very important to get this view, international view. And I think we need to become more international in Brazil regarding arbitration, and or maybe to use more international standards regarding legitimacy. It goes beyond the legality. I will explain a little bit when I have opportunity.
Okay.
Carmona, thank you for this.
Thanks, Andrea. Thank you. So now the floor is yours, Claudio. People in arbitration.
Sure. Thank you, Professor Carmona, and thank you for the invitation to the organizers of this panel. What I wanted to touch upon today is an old criticism of arbitration, longstanding, that it's an exclusive club with only a few players. And one can see this in three phenomena that I want to discuss today: multiple hatting, repeat appointments, and reciprocal arbitrator appointments. So for each one, I want to kind of define clearly what the practice is, and then identify issues specific to each, and then end with what I think is a broader observation about these practices. So starting with a multiple hatting, this is when one professional serves as both counsel and arbitrator. Sometimes there are more roles involved. They could also be the heads of arbitral institutions. They could be experts. They could be academics. And I think this is part of the history of arbitration being kind of a subset and a flexible one, that historically it's allowed to have prominent players perform these different roles, which is not the same, for example, in court litigation, where you can either be a judge or you can be a counsel, but you're not both. You're not playing both roles. I think the most obvious criticism of double hatting is a conflict of interest. So classic situation might come up when you are both counsel in one case and an arbitrator in another case, and the same issue comes up. And the fear is that your decision in one will be affected by your interests in the other. And this is perhaps most clear in investor-state arbitration, in which decisions are public and where decisions could be quasi-precedential. And so you could literally have someone decide a case in a way that will affect or will influence another case in the interest of their clients in another case. I think the dynamic in commercial arbitration is still there. It's maybe more subtle, maybe more subconscious, the effect of playing these multiple roles. But again, the fear is kind of an infection from one role to the other. The next phenomena that I want to talk about is repeat arbitrator appointments. So here is, again, a kind of a long-standing practice of parties appointing or counsel appointing the same arbitrator repeatedly times. And there are several explanations for this. One of it could be that traditionally there might have been a view that there were only a limited number of arbitrators that could resolve complex disputes or disputes of a certain size, and so you were getting the same arbitrators appointed over and over again. You could have counsel that was comfortable. They sort of felt like they knew somebody and they knew how they would run the show and they would want to appoint them. And another one, and perhaps a little more problematic, is that you thought that you knew how the arbitrator would decide. And again, this is more prominent in investor-state arbitration, where some arbitrators have the reputation of being having a state bias or having an investor bias, a pro-state or pro-investor. And again, the traditional criticism to this is conflict of interest, right? So if an arbitrator is repeatedly appointed by the same party or by the same counsel, you fear that they might grow financially dependent on that, or at least have some sort of sympathy toward that party over time and some sort of perhaps bias toward that party. And in fact, the problem is well known enough that it features in the IBA conflicts of interest guidelines on the orange list at 3.3.8. Kind of a potential flag is that an arbitrator has, within the past 3 years, been appointed on more than 3 occasions by the same counsel or the same law firm. The last phenomena that I want to touch on is reciprocal arbitrator appointments. And this is when arbitrators are appointing each other to other panels. So, for example, if you have arbitrator A and arbitrator B sitting on the same panel, and then on a separate arbitration, arbitrator A with their co-arbitrator jointly nominates arbitrator B from that prior panel to be the chair of that second arbitration. And you could, even if you mix it with multiple hatting or double hatting, it could become worse, because you could have the counsel appoints the arbitrator, and then when the arbitrator is counsel, appoints the prior counsel as arbitrator. So these are what's known as reciprocal appointments. And here, the allegation the classical allegation could be, again, of bias. Of course, if arbitrators are trading favors with each other, or they're sort of growing chummy with each other, you maybe start fearing as to how that's affecting their decisions and how that could affect parties in particular cases. I think here maybe the concern is a little bit more removed than, for example, in repeat arbitrator appointments, but that's the concern. And I know of at least a couple of cases in the US where parties have brought the non-disclosure of the fact that you're in other panels with arbitrators in the panel as a cause for annulment. Those cases haven't been resolved yet, so I don't know if that'll succeed. That is the allegation. So what I've described as a problem with these 3 practices is sort of the classical criticism that goes to legitimacy, which is, if you cannot get unbiased results from arbitration, then of course arbitration cannot be a legitimate form of dispute resolution. However, I think that the criticism is really, in my mind, goes beyond that, because I'm not sure how many times there is conscious bias that results from these practices. I think maybe the bigger problem is that this these practices feed into the perception and the reality of arbitration being an exclusive club, and perhaps an exclusive club of older white men. So you have the same players who are counseled and arbitrators. You have the same arbitrators who get nominated over and over again. You have arbitrators who start nominating each other, and this leaves little room for new faces and fresh ideas. As Professor Stavros mentioned earlier, I think representation is key if international arbitration is going to be a global dispute resolution that's going to affect men and women from all nationalities, races, and ethnicities. There must be representation of the people who make the decisions and the arbitrators. So I would posit that perhaps these practices are more detrimental with respect to diversity and that source of legitimacy than they are with the classical criticisms of bias. And so with that, I turn it over to the other panelists on their views on these practices.
Okay, thank you, Claudio. But first of all, you were talking about pathology. And my question is, this pathology that you are describing can be controlled by the soft laws. Is it enough?
I think there's the soft laws like the IBA guidelines can make specific rules. So for example, with repeat arbitrator appointments, but I don't think that goes further and far enough. I think the appointing different arbitrators and arbitrators of women and men and of different nationalities and different races has to come with the parties, with a council, with arbitral institutions. And I'm not sure if I don't know if guidelines like the IBA guidelines are really going to sort of change behavior. Unfortunately, I'm not sure what will change the behavior. For example, I understand why arbitrators who may know each other from serving on a panel may be tempted to appoint each other to another panel because they know each other. So I think soft law are helpful, but it's maybe more of a cultural change or educational change.
So would it be better to let the center of arbitration or the chamber of arbitration to appoint all the arbitrators?
It's funny because there was a Queen Mary survey on diversity a couple of years ago, which the suggestion was that yes, that arbitral institutions were where the solution was going to be. People thought that 45% of the respondents thought that that's where the solution was going to come from. I think you start running into serious problems with parties wanting to appoint their own arbitrators. I guess the institutions can be helpful with chair. So maybe part of the solution, but not the complete solution.
But arbitration is a system of freedom. So if you are going to intervene in this freedom this way, you are going to destroy the system. You were going to transform the system of arbitration and the system of the procedure of judiciary. So no difference, and so go to the judge, and arbitration is over. I don't know. It is a very long discussion, and I
didn't agree with Carmona. I didn't agree. I think arbitral institutions can. Sorry.
Just a moment.
I don't know how can I raise my hand here.
Sure. Just a moment. I'm asking you this question, Claudio, because I have a question here from Agenor Filgueiras, and this was a question I would like to ask you, but he formulated a question in a best way. I'm going to read.
Sorry.
Oh. The question is, in Brazil, a recently launched Bill seeks to amend our Arbitration Act to prohibit any arbitrator sitting in Brazil to have more than 10 arbitrations at once. It would also forbid the existence of similar tribunals. How does Claudio and the panel see this legislative initiative? Would it solve the problem? Here you have a problem to make a surveillance over our parliament in order not to permit them to make those, we call them jabuticaba. Jabuticaba is a fruit that exists only in Brazil, and our parliament loves to make this fruit in the legislation. So we want to be different from every other country in the world. And there is this project in the Congress, and they want to make this limitation. What do you think about it? Only 10 arbitrations at the same time, and never to sit in a panel with another arbitrator that you have that you were working with in another panel.
Yeah, I think, I think it sounds like a good idea in theory, but I think it does cut into the freedom of that you're that's mentioned earlier, Carlos. I think when you start putting in such fast constraints, I think it takes away maybe from the attraction of arbitration. But, the ICC and other institutions already make arbitrators reveal how many arbitrations they're on. And if parties are smart, and I hope, they may not go for the big name, but go for somebody who's more availability. I would hope, anyway. The attraction of the big name might be too much for some parties. But then they're going to get the costs and time that Susan was referring to when they don't get a decision in 10 months or 12 months.
Well, depending on your structure, there are some arbitrators that are working only with arbitrations. So you don't have cases in the courts, and you have time to dedicate to your 10, 20, or 30 arbitrations. It's up to you. If you are an engineer, you have to be 1, 10, or 100 constructions. It depends on your structure. Who is going to say to me to limit my activity if I am able or not to produce in 1 year, 1 year and a half, a good decision? So it's up to me. Of course, the parties can ask me, how many arbitrations do you have? How many arbitrations are you administering? Because from the point of view of the parties, perhaps I don't have the time for that arbitration. Up to the parties. But come on, this is freedom. And please, I'm going to erase the beginning of your speech when you said, oh, it seems to be a good idea. No, it's not a good idea. So perhaps this member of the parliament listen to you and think that you are supporting this horrible idea. No, this is horrible. This is absolutely negative. No, it's a bad idea. Andrea, you wanted you raised your hand.
I don't know how can I raise my hand here, but that's okay. But I think we need to focus on the real question here. Why I need to disclose how many arbitrations or how many heads I have? Why the legislature wants to do that? What is the problem in Brazil? That's the focus on. And I see it goes to the legitimacy in the process of choosing arbitrator, or something is going wrong in that process, Professor Carmona. And it seems to me that intervention is not good for arbitration. But in the end of the day, if you don't disclose how many arbitration do you have in the outset in arbitral institution, I think the arbitral institution could self-regulate these issues better than legislator. But I have seen in Brazil some problems, and courts have this how can I say, some bias or some suspicion regarding this process, because parties don't know how many arbitration do you have. But once choose you, maybe can be a problem during the arbitral process, because there is another arbitration is coming, and the same panel is the same in another arbitration. And why? That is the question. Why not to disclose? What is the problem to disclose? In my view, when you choose arbitrator, you have a prime directive of legitimacy. What do parties hire you to do? Answer is the only one, in my view, to produce an enforceable award that resolve all issues presented by parties. No more, no less. But parties and users don't know how many arbitrations, similar arbitrations, do you have? And why it's a problem for arbitral institutions disclose them between parties. And what is the problem? For our judge, it's not our problem because it goes to legitimacy. We'll see only this problem in the end of the arbitral proceeding or after arbitration award, when one of the parties go to the court and say, well, this is a problem here. The same arbitrator is saying a similar case, or the same panel, or how many heads, whatever, and this is a lack of impartiality. Even if there is no lack of impartiality, one of the parties will try to set aside the award. I think self-regulation in Brazil is the most important issue of the legitimacy, because once you this negatively issue is not solved by arbitral institution, legislature will do this job, or judiciary. And because we are in Brazil, we have a civil law system. It's the matter of the law. We have the arbitration, Brazilian arbitration law, who says this is a duty of the disclosure, any circumstance. There is a matter of the law also. And I think the arbitral institution internally, administratively, can resolve this issue easily. Better than legislator, of course. But there is, if the first members of the arbitral Brazilian community continues to deny that problem and say that, or we need to be free, we need to be without any control, it will be a problem in the end of the day. In that problem, you go to the court. That interplay will, as a judge, we don't know how arbitration is inside. We don't care about exactly during the process. But when everything is going wrong, we need to act to control under legality, under Brazilian Arbitration Act. That's the problem. I think we need to do in Brazil and the self-regulation and also the self-criticism and being more international, using more the guidelines or ethical international standards as AAA, ABI guidelines, CIR, whatever, to become more international. No small community wants to be free no matter what. That's my view, Professor Carmona.
Thank you, Andrea.
Sorry, it can be hard, but it's my view. We have a problem in Brazil. We need to solve.
And as you can realize, we disagree completely, because arbitration is going all right, and we don't need disapproval from the judiciary. There are very, very few cases of annulation of setting them.
For sure, we are pro arbitration, not against it.
No, it's not a problem to be pro or against arbitration. It's the way you see arbitration. So if it is important to the parties to know, if you are a member of 1 or 2 or 3 or 10 panels, you ask the arbitrators and he's going to answer your question. So it's a problem of curiosity. If it is important to you, ask the arbitrator is going to answer your question. So this is not a problem to be controlled. And if you were a member of a panel that is discussing a similar question, ask the arbitrator, are you a member of a panel who is discussing the same?
You must disclose this issue. to avoid any problem during the arbitral proceeding or in the end of the arbitral proceeding. That's my view.
I disagree because it is impossible to think about what is important to the parties in order to disclose. Perhaps you are going to disclose a book of things which are important to the parties. You can't guess. So the party is able to ask questions, and I will answer whatever is important to you. But you know that we disagree. This is important to know. And Claudio, only two remarks. Yes, Susan. Only 2 remarks. We call this club of people that repeat and arbitrate. We call it in Brazil country club, and this double hat we call it a revolving door. Okay, this is the expressions we use in Brazil to express this situation. This double hat is a revolving door. Susan, please.
I want to flag that I first experienced Brazilian arbitration law, I think it was in 1998, right after the law had just changed. And I remember, I think I've got the language right, that compulsoria was a major change. And I've always admired Brazil's capacity to do a lot of internal self-reflection, as the debate amongst the panelists just reflected. What I want to add is a bit of context and flavor. Namely, it seems as if we're assuming all disputes are the same, all arbitrators are the same. Rather, I would suggest it's not one size fits all, but every dispute is different. To the extent that a hard rule, we wouldn't tell doctors or lawyers you can only have 10 clients. To the extent that I'm going to go down the self-regulation route, which surprises me, but there you go. We've got lots of disincentives from people taking cases, but not everybody has these incentives. For example, I wouldn't ever take more than 10 cases because my job is to be a professor and to teach my students and to write my scholarship. So I only take a few number of commercial cases to make sure I maintain quality. That's my choice. Whereas in law firm, partners, they have conflicts of interest that will prevent them from taking on cases. So different people will have different incentives. So my suggestion is to encourage the Brazilian legislature to think long and hard about negative externalities and unintended consequences, because the people that we want to regulate are actually not the high quality people. It's the cowboys. So think about what will incentivize cowboys to keep them in line and to ensure party choice is honored and integrity of process is maintained.
Sorry, people. I think I have a problem with my connection.
Stavros?
I have a problem with my connection. Sorry.
Okay, can I very briefly say something?
Sure, Stavros.
Well, thank you, Carlos. I think this is a fascinating discussion, and I don't want to add to it too much, in the sense that we've been discussing about partiality, impartiality, and the perception. They are very, very important discussions and debates to have. But I think I would like us to take the discussion back to the question of diversity, which Claudio discussed in the first place. And I don't think that the question of diversity is necessarily a question of impartiality or lack thereof. I think the consideration that we have members of tribunals sitting in arbitration panels that are representatives of the demographics of the users of arbitration, it is a value of itself. We don't want diversity because it will be less partial tribunals, or they will have fewer connections and this small group of arbitrators. We want diversity because this is the right thing to do. It is an important value for arbitration that we need to aspire to, and this is a value of legitimacy at the end of the day. So we have a long way to go in terms of diversity, and again, not necessarily to improve lack of partiality. If you ask me, lack of partiality is not a major issue for I think, as Susan said, we have few cowboys, probably, but broadly speaking, arbitration has very few cases of evident lack of impartiality. Most people that work as international arbitrators know that their reputation is the most important value that they have, the most important currency that they have, and they keep it as much as they can. They will not necessarily risk any decision that will be come across as a decision that lacks impartiality. So I don't think that the major issue currently in arbitration is any perceptions of lack of impartiality. Diversity is, and I would welcome some of the comments, and I will endorse some of the comments that Claudio made in this respect.
Thank you, Stavros. And now, last but not least, Andrea, interplay between courts and arbitration. Please, the floor is yours.
Hi guys, it's a pleasure to be here as a judge. I know I am a stranger in this arbitral community, but I will take this opportunity to speak on behalf of on my judiciary, especially in São Paulo. And I will ask permission to give some thoughts about legitimacy and legality, a little bit academically, but I promise you it's quick. It's quickly. For judges, legitimacy is a matter of the law, synonymous of legality. And whether a judge or someone representing the public administration, legitimacy includes competence to run on disputes on impose measures. Therefore, both terms, competence and jurisdiction, are sometimes used as synonyms. Under Brazilian law, competence of the judiciary is addressed in the federal constitution and legislation. Competence of arbitrators is instead is a matter of the contractual arrangements in Brazilian Arbitration Act. The aforementioned understanding of legality and legitimacy built on H.L.A. Hart's legal positivism and developed by his scholar Joseph Hess, and opposed to Dworkin, who integrate the moral categories into the theory of the law and legality, thereby blurring the borderline between the two categories. However, legitimacy, the topic of our panel, is a concept that goes beyond the competence and legality. It includes moral and ethical, but also procedural categories. I refer to procedural justice. I'm referring. Yet, in the ever more regulated world, this generic category has been largely absorbed by a legislator or regulatory agency. In the world of the arbitration, also by private standards, such ABA, AAA, ACDR, CRB, or other NGOs, which, however, lack the democratic legitimacy and authority. Legitimacy in arbitration is a matter, for me, of the contract. It's a private dispute resolution process. Why arbitration, though? That's my question. It's better adapted to the character of commercial a transaction, especially internationally. Parties have the right to select the arbitrators. Arbitral adjudication is more flexible, less complicated compared with legalistic solutions rendered by courts. Economy of time and money plus efficiency. Expertise of the arbitrators compared with the unexpected judges. An expert judges. Confidentiality, integrity, impartiality, independence bound by ethical standards. The prime directive of legitimacy, as I mentioned before, goes to the question, what do parties hire you to do? Answer, to produce an enforceable war that resolves all issues presented by parties. No more, no less. Issues, in my view, can jeopardize the legitimacy. Process of appointing arbitral institutions must to be more strong about these rules. We have Article 11, Item 2 for the model law, and in Brazil, Article 13 and paragraph 1 and 3 to address this issue. I think it must be an objective criteria such responsiveness and expertise in the subject matter of dispute instead of personal or economic interest. Or if the choice is guided by strategical thoughts, such as, will this colleague appoint me upon next opportunity? Or will he or she be harder weak in tough deliberation? Identical arbitral tribunal can be another issue because they are signally strategic behavior, if not moral hazard. How many hats should arbitrator have? Should be disclosed to the parties? Why not? Or this is an issue, it's a justifiable doubt to disclose. Another issue that is very important is, for me, especially in Brazil, refers to expertise. Whenever I listen to a speech held by a representative of arbitration community, he and she emphasizing at least two arguments to provoke arbitration: speed and expertise. I have seen in Brazil so many arbitrators serve in several kinds of disputes as a specialist, sometimes in agribusiness, another times in corporate law, construction arbitration, energy, industry, and public administration. It's kind of, you think it's kind of issue you should be taking into account if you are qualified for qualified for all kind of disputes. Let's say we are expert in certain types of disputes or subject matters. It's certainly a question of legitimacy to keep that promise. So if you promise to the party you are expert, you should or you must to comply with. This understanding of legitimacy builds on H.L.A. Hart's legal positivism, as developed by his scholar Joseph Haas. But even if we follow instead Dworkin and House, who integrate moral categories into the theory of law and contracts, arbitrators' legitimacy still depends on them keeping their promise to be an expert, if they gave such a formal or informal promising. What does it mean in a practice? I have few minutes to finish. Well, it simply means not accepting appointments for each of every kind of dispute. Justice Cueva, Minister of Superior of Justice in Brazil, recently in a speech that pointed out this question, whether an arbitrator is an expert, is an important source of legitimacy of the legal institute. This is a kind of issue you should take into account. To be clear, he was not talking about procedural know-how, but expertise in certain area of substantive law. Many users do not have access to first-hand information on the expertise of arbitrators. They must rely on second-hand information. On the other hand, users of arbitration have an active part in guaranteeing legitimacy of arbitration. As Gary Bourne points out, choosing an arbitrator is an important right of the parties, but also a responsibility. Thus, parties that choose arbitrators with the sole objective that he or she will deliver the desired vote, whatever may come along the proceedings, they may be successful in a specific case, but they undermine and jeopardize the legitimacy of the arbitration as a legal institute. Let me resume. Legitimacy is a legal concept that goes beyond the law, regulations, and rules. Therefore, the fact that one arbitral tribunal lacks legitimacy will normally not have immediately legal effect of arbitral award rendered by such tribunal. But in other words, lack of legitimacy is not as such a reason to set aside an award. But however, if the lack of the legitimacy is persistent in arbitration market, it will sooner or later provoke a reaction by the legislature or judiciary. Therefore, the arbitration community should have a self-interest to preserve and improve its legitimacy by concrete measures, for instance, regarding caseload, cross-the appointments, diversity, and that does not only mean gender diversity, but internationality, different professional backgrounds, alumni of different law faculties, etc. I hope the arbitration will continue to flourish and not destroy itself by making the same mistake we have seen in other countries. Establishing a market barrier by pretending that we are special is not good in Brazil. I can say, fortunately, in Brazil, the interplay between courts and arbitral community, I can say it's a summer, not a winter. We have been set aside arbitration award in a few cases since the edition of Arbitration Brazilian Act. However, after 15 years of growth, it's only natural that some issues have arisen. Notably, arbitration in Brazil started to grow in 2004 and in 2005, as CAM-CCBC numbers clearly demonstrate. Thus, we are talking about teenager who is about to get an adult. The arbitration community, especially its first generation, needs to admit that not everything is marvelous. But if this community is not willing or capable to improve the self-regulation regarding legitimacy or ethical standard, it is obvious that the legislature will step in. Brazilian law is a civil law system with high degree of legislation and meticulous constitution. Arbitration in Brazil must be aware of this framework. That's my words. And regarding the issue, and if we are pro-arbitration, I can say, especially in São Paulo and the superior courts, we are supportive regarding arbitration. And we have been set aside few cases, it's rare. But the question regarding legitimacy is very important to Brazil. And not because sometimes some issues is not a ground to set aside on a war or to jeopardize the proceeding, but could be for institutional Brazilian arbitration. And I think the self-regulation and the self-criticism, it's very useful for us. And being more international, open-minded, open market to the others, especially internationally. Thank you, Professor Carmona. Thank you, Professor Stavros, for the audience.
Thank you very much.
Sorry,
People,
take too long.
I'm receiving the message from the coordinator that we have to finish our panel. Our time is over. Thank you very much, Andrea, Claudio, Susan, Stavros. It was a pleasure to be with you this morning here in São Paulo. And I hope next time you come to Brazil, okay? Thank you very much.
Bye-bye.
Thank you. Bye.
Nós agradecemos os integrantes do primeiro painel e seguimos com a programação do Grupo Jovem New Generation CAM-CCBC. Convidamos ao palco, então, Daniel Tavela para comandar os trabalhos do Momento New Generation e no convidado especial, nosso convidado especial, Carlos Forbes.
Bom, muito bom dia a todos nesse Momento NewGen, que nós começamos hoje recebendo um convidado muito especial para nós, o Dr. Carlos Forbes. Como vocês sabem, o Momento NewGen, tradicionalmente no Congresso do CAM-CCBC, é para a gente fazer um momento um pouco mais descontraído. E nessa pandemia a gente aprendeu que uma das melhores formas de ter um momento descontraído, que traz um pouco daquela aproximação que a gente não consegue ter por estar próximo, é contar história. Então, os momentos que a gente vai passar aqui no Momento NewGen hoje e amanhã é para ouvir um pouco mais de histórias. E ninguém melhor do que contar algumas histórias também para nós do que o Dr. Carlos Forbes. E, Carlos, aqui a ideia é a gente contar um pouquinho sobre experiências que já foram vividas na vida da advocacia, na vida como árbitro. Eu queria ouvir de você, porque eu sei que você tem muita história para contar.
Tem muita história para contar.
E aí eu queria ouvir uma história boa sua, que eu sei que você tem, e que fala um pouquinho sobre essa relação de arbitragem, códigos de processo e o sistema multiuso. Que é isso? A arbitragem, além de tudo, nos ensina coisas incríveis sobre como utilizar um código de processo civil, não é mesmo?
Com certeza. Bom, Daniel, muito obrigado obrigado pela iniciativa NewGen ter me convidado. Obrigado, Eleonora Coelho, ao CCBC por fazer esse congresso. E, na verdade, sim, tem um monte de história. Mas você sabe que eu estava pensando, é mais fácil contar histórias como advogado do que como árbitro. Árbitro, você está sempre tão focado no procedimento, no que está acontecendo, que como advogado é que você tem que estar atenado e vendo todas as coisas. Mas eu me lembro, há muito tempo, numa arbitragem, a audiência iniciando, ainda era no CAM-CCBC antigo, na Faria Lima, que tinha uma folha maravilhosa que imitava um plátano.
Era aquela fácil de fazer audiência.
Pior, porque você ficava de costas para a parte contrária, era um caos. Mas chegamos na audiência, meu cliente, chegou o advogado contrário, que era um desembargador aqui do Tribunal de Justiça muito conhecido. Ele tinha acabado de sair da magistratura e tinha iniciado na arbitragem. Bem, eu sentei com meu cliente, os árbitros, boa tarde, boa tarde, boa tarde. Esse advogado senta, pega a sua pasta, coloca em cima da mesa e abre. Quando ele abre, ele tira um CPC, um Código de Processo Civil do Teotônio, gigantesco, e põe em cima da mesa. Tudo bem. Um dos árbitros, que aliás acabou de ser o moderador do painel anterior, ele vira para esse advogado, ex-juiz, e diz: doutor, é um prazer tê-lo aqui. Espero que o senhor tenha trazido o CPC do Teotônio como peso de painel, porque Código de Processo Civil não se aplica à arbitragem. Então, esse negócio de CPC é sempre muito engraçado, né? Porque todos começamos como advogado de contencioso e sempre tínhamos aquela coisa de estar vendo a lei, mas na arbitragem é diferente. Na arbitragem você tem que modelar.
E ela efetivamente virou um peso de papel, ela foi atirada
Graças
por ali.
A Deus, não. Ele ficou bastante constrangido, mas não perdeu a fleugma, deixou o CPC durante toda a audiência. E eu devo confessar, cada vez que eu olhava para ele, olhava para o CPC, eu dava aquela risadinha, assim, meu Deus, começou mal.
Começamos mal, pois é, mas a gente começa muito bem o nosso painel e a gente aprende já duas coisas aqui que são muito importantes, né? A primeira, lugar de CPC continua no processo civil. A segunda, árbitro é um sujeito muito focado. Não importa a aparência que ele tenha no seu painel, não é mesmo?
Na verdade, sim. Em uma outra ocasião, numa audiência de instrução bastante complicada, onde uma série de perguntas e conversas e protestos daqui, o meu cliente, que estava sentado ao meu lado, vira e diz assim: Dr. Carlos, um dos árbitros está dormindo. Eu olhei, e realmente o árbitro parecia que estava dormindo. Eu tive que falar,
compenetrado,
não.
assim, compenetrado?
Ele estava assim, tipo... Ele estava até de olho aberto, mas você sabe que tem umas pessoas que conseguem dormir de olho aberto.
Eu sempre quis ter essa habilidade e nunca consegui.
Mas eu consegui isso na pós-graduação e foi várias vezes utilizada, muito bom. Tá?
Eu tenho quase certeza que meus alunos também conseguem isso.
Imagino. Mas ele estava com uma cara, eu acho que ele fez aquele tipo, sabe, Chico Xavier, que fica pensativo. E eu disse, não, de jeito nenhum, ele está prestando atenção. Passou um pouquinho, ele vira de novo, disse assim, Dr. Carlos, eu acho que ele está dormindo. Disse, olha, ele não está, mas eu vou levantar meu tom de voz, que já é bem alto, como você bem sabe. Bom, a audiência continua. O presidente do Tribunal Arbitral perguntou, senhores, tem alguma pergunta? De repente, não mais que de repente, esse árbitro tira a mão. Eu tenho uma pergunta. Senhor depoente, se isso fosse isso, aquilo seria aquilo e, portanto, a conclusão é esta? O depoente, o senhor tem toda a razão. Se isso fosse isso e aquilo fosse aquilo, a conclusão é exatamente essa. Bom, eu quase aplaudi. Primeiro, porque eu não tinha conseguido fazer essa pergunta. Depois, ele fez, ele obteve a resposta e nós ganhamos o processo dessa maneira, em função dessa pergunta. O que significa dizer? Não subestimem. O árbitro está sempre prestando atenção. Ele está sempre entendendo o que está acontecendo. E, ao contrário do que algumas vezes acontece na magistratura, porque eu fiquei sabendo que você também tem uma história de magistratura, né?
Tenho.
O árbitro está ali para aquele processo inteiro. Ele fica o tempo que você precisar.
A minha história já é um pouco diferente, né? Porque eu tenho casos de um juiz vidente.
Juiz vidente?
Um juiz vidente, exatamente. Porque o que aconteceu nesse caso era a colheita de depoimento também da parte contrária, um caso super importante. A gente estava na audiência de instrução e eu, enfim, depois de muito tempo também já advogando em arbitragem, levei o meu bom e velho bundle de perguntas, né? Eu tinha uma série de perguntas para fazer para o depoente da parte contrária, essa audiência já estava se alongando. A gente já devia ter algo como 40, 50 minutos de tomada de depoimento num processo judicial, que não é algo que você vê todo dia. Chega um determinado momento, eu começo a fazer algumas perguntas a mais para a parte contrária, e o juiz me diz, doutor, a sua pergunta está indeferida. Até aí, me parece normal, de vez em quando você passa uma pergunta a mais aqui e ali. Excelência, veja, esse ponto se conecta diretamente com o item A do nosso despacho saneador, né? Saudoso despacho saneador. E aí, ele me diz, doutor, está claro que a sua pergunta está indeferida. Aliás, estou indeferindo toda a sua linha de perguntas adicional. Não quero nem saber qual é, elas estão absolutamente indeferidas. Essa audiência, aliás, se encerra aqui. E aí eu fiquei pensando, né? Eu falei, mas, excelência, eu tenho todo o direito de fazer essas perguntas. E ele me disse, e eu tenho o dever de indeferi-las. Esse é o momento.
Mas você sabe o que é isso, né, Daniel? É falta de tempo. Nisso, o árbitro ele é muito mais próximo do procedimento. Eu tenho uma outra história também. Estamos lá no escritório, circula uma manifestação da parte contrária, onde ele informa ao tribunal arbitral que o perito estava vendendo o seu laudo. Cara, eu li aquilo assim, ui, eu nunca... Que coisa
grave.
Socorro, né?
Exato.
A primeira coisa que eu fiz, obviamente, foi ligar para o meu cliente para perguntar se ele, por um acaso, tinha comprado o laudo, coisa que ele não tinha feito, porque eu já tinha proibido. O tribunal, como tinha tempo e estava atento, ele imediatamente soltou uma ordem processual marcando uma audiência para o dia seguinte, dizendo que já tinha conversado com o perito para que ele não se manifestasse e não falasse com nenhuma das partes e que ele aguardava todo mundo no dia seguinte, às 10 horas da manhã. No dia seguinte, 10 horas da manhã, doutor, mas o que aconteceu? O advogado contrário, não, você vai saber, você não sabe a loucura que foi. Aí eu disse assim, mas dá para me adiantar? Não, não dá. Ok, vamos lá. Entramos, sentamos e vira o tribunal. Sim, doutor, o que aconteceu? É melhor ouvir o árbitro. É muito sério. Eu não faria essa acusação em vão. Bom, entra o perito, naquela cara de mau humor, né? Mas entra o perito. Sim. O senhor está chamado aqui porque o doutor fulano disse que o senhor ofereceu a venda do seu laudo. Oi? Foi o que foi nos trazido, por isso nós marcamos essa audiência com a emergência absoluta para que você explicasse. Eu não estou entendendo.
Ele já tinha soltado o laudo, não?
Não, o laudo não tinha soltado. Mas, o que aconteceu? Já sei, disse o perito. Eu estava na empresa fazendo o que eu tinha que fazer, buscando documentos e informações. E o assistente técnico veio para mim e disse, quer mais alguma coisa? Quer um café? O que você está escrevendo aí? Daí ele disse assim, olha, estou fazendo o laudo, estou tomando uma série de anotações, mas eu posso te ajudar. Eu disse assim, eu não quero sua ajuda, eu sou o perito, você é assistente técnico, a gente vai fazer uma reunião. Mais do que isso, eu nem deveria estar conversando com você sem o outro assistente técnico estar aqui. Mas o senhor não quer mais alguma coisa? Eu disse, olha, eu não quero mais alguma coisa. Não, mas eu estou aqui para ajudar isso aqui. Daí o perito disse que ele ficou nervoso e disse assim, o que você quer? Você está querendo comprar o laudo? Aí o outro ficou pau da vida e saiu. Silêncio assim. Aí vira o advogado para o seu cliente. Foi isso que aconteceu? Daí o cliente diz, foi. A cara do advogado, simplesmente porque o perito ficou aborrecido e nada tinha havido. Ele mobilizou todo um tribunal, todo um procedimento para um fato que era totalmente inexistente. Tá? Bom, lições a tirar disso. Primeiro, o tribunal arbitral está sempre disponível. E isso é essencial, isso é uma das belezas da arbitragem. 2, você enquanto advogado, aí sim, em arbitragem, em processo judicial, ou em qualquer lugar da sua atuação, você tem que saber o que o seu cliente vai falar. Não adianta você imaginar que o seu cliente está certo. A interpretação dele não é necessariamente a interpretação jurídica que tem que se dar ao fato. E se você não faz isso, você pode simplesmente escorregar numa audiência desnecessária, num incidente inexistente.
Uma bela casca de banana essa,
né? Com certeza absoluta.
Bom, e com isso, gente, a gente tira lições absolutamente incríveis, né? A primeira, claro, CPC, 1001 utilidades. No processo judicial, certamente com todos os seus artigos. Numa arbitragem, como talvez um belo peso de papel.
Nem tão belo assim, né? Porque
ele é muito pesado, grande,
é muito pesado e às vezes atrapalha.
Hoje eu tenho visto um pouco deles assim sendo utilizados em monitores, né? Para dar aquela ergonomia que às vezes você precisa.
É verdade.
Mas além disso, a gente aprendeu um pouco mais sobre essas belezas da arbitragem, de ter um tribunal disponível, de ter um árbitro atento, não importa a cara que ele esteja fazendo. Ele pode parecer que está lá, dormindo de olho aberto, mas ele está atento ao seu procedimento. E mais, quando as alegações são sérias, muitas vezes você tem uma audiência imediata, no dia seguinte. Então você tem que estar sempre preparado. Aliás, diz o ditado, profissionais estão sempre preparados.
É verdade, mas diz outro ditado, que eu vou criar agora, não tente adivinhar quais são as perguntas que vêm do advogado. Ouça primeiro antes de indeferi-las.
Ótimo. Essa mesma. Para vocês que gostaram desse Momento NewGen, amanhã tem mais, e tem mais Momento NewGen com doutora Adriana Bragueta, professora Catherine Rogers, recebidas aqui pela Fabiana Leite, da nossa NewGen. Muito obrigado para todos vocês que estiveram aqui conosco hoje. Até mais.
Tchau, gente. Muito obrigado.
E nós retomamos nossas atividades com o segundo painel. Tema central, para além das questões processuais, disputas contratuais em tempos de incerteza. Para compor este painel remoto, nós convidamos Rodrigo Fonseca, advogado, árbitro e sócio da Fonseca e Salles Lima, advogados associados. Maxi Scherer, professora de Direito da Universidade Queen Mary de Londres. Victoria Sarrani, professora de Direito da Faculdade de Direito Sandra Day O'Connor, na Universidade Estadual do Arizona. Mohamed Abdel Wahab, professor de Direito da Universidade do Cairo, sócio fundador da Zulfikar e Partners. E na moderação, Ann Ryan Robertson, presidente global da Chartered Institute of Arbitrators e sócia da Locklord em Houston. Com a palavra, então, o moderador desse painel, moderadora melhor, Ann Ryan Robertson.
The next enlightening as we explore the topic of beyond the procedural issues, contractual disputes in times of uncertainty. We would be pleased to take questions, time permitting, at the end of the presentation, so please feel free to send questions to us. I'd like to start, if we don't mind, Rodrigo, with you, with the first question being, we are being repeatedly told that we are living in uncertain times, and in support for that statement, the press and the public point to the pandemic and climate change as prime examples. Are we, in fact, living in uncertain times?
Good morning, everyone. Thank you, Ann, for your question. Before I address your question, I'd like to briefly thank all the organizers and CAM-CCBC fantastic staff. Are you listening? All right. Well, it is an honor to participate in this event. And as you said, the theme of our panel is uncertainty. And this has been prompted clearly by the COVID pandemic that makes us feel to be living in such uncertain times. But if we look back 30 years, for example, and I graduated from law school in 1989, this was the year the Berlin Wall fell. And so over the last 30 years, we had the end of communism. 2001, we had 9/11. 2008, the financial crisis, the fall of the bankruptcy of Lehman Brothers and everything that followed. Then we have the COVID pandemic. So every 10 years or so, we have a major crisis. If we look at Brazil, 30 years ago, we were amid hyperinflation. We had, from then on, we've had 2 presidents impeached. We've come from leftist governments to the present government. So it's very hard to say that there ever is a time of certainty. I believe we kind of feel that we are living in a time of certainty when we're actually just waiting for the next crisis. We have a certain illusion that times will remain calm, and that never happens, actually. That said, we learn and we evolve and adapt as time goes by. I think after the COVID-19 pandemic, no one will think of force majeure, for example, as they did before. No one will write contracts and certain kinds of clauses the way they did before. No one will decide certain cases the way they did before. Maybe, for example, in investment cases, arbitrators may be more willing to accept the legitimacy of certain governmental actions to protect the economy, to protect the people in general. So I think what we need to learn is that our there are always new crises and new events that shape the future, and they impact the way that we look at cases, the way that we practice law. Our personal experience always influence the way that we do business, the way the lawyers will argue the cases, and the way judges and arbitrators will decide them. So these are some opening remarks so that we can further discuss. Thank you, Ann.
Thank you, Rodrigo. Victoria, do you have anything that you might like to add to what Rodrigo has shared with us?
Yes, thank you, Ann. I think Rodrigo's comments were very compelling. And I just would like to add that in addition to his point about the cyclical, repetitive nature of crises in modern times, I would also like to point out that if we look at human history as a whole, there is more certainty now for global businesses than there ever was in the past. For example, there is a stable network of governments around the world that's interested in promoting cross-border business. We have 168 members of the New York Convention and 164 members of the ICSID Convention, compared to very few nations when those conventions were originally adopted. Courts around the world are much more accepting of international arbitration, and they're willing to enforce arbitration clauses and arbitration awards. And businesses tend to abide by contracts, even when they are from vastly different cultures. Therefore, I think our modern notion of uncertainty might really just be the growing pains of changing our modes of working. But the fundamental foundation of the global business dispute resolution system remains solid.
Thank you. Would anyone else like to comment on this particular question before we move on? Mohamed?
Thank you very much, Anne. I can briefly say the following. Of course, it's a great pleasure to join you on this stellar panel, and I'm very grateful for Rodrigo's and Victoria's excellent comments. I can only add one key development that I see already taking place or shaping up, which is basically more attention by all stakeholders to crisis management. In a post-COVID world, people are realizing more and more that they need to have in place crisis management policies, and that includes elements of communications, dispute avoidance, dispute management, and finally, of course, dispute resolution. But I think we will be seeing more and more of these policies integrated into corporate and state practices about how best to respond to crisis as and when it transpires.
Thank you. Let's turn to another question. Maxi, the pandemic has been with us for over 18 months. Countries have been shuttered, and only now is international travel once again beginning. What impact has this pandemic had on arbitration?
I think we can't hear Maxi.
Right.
I think we can't hear Maxi. Are you on mute?
I don't think I'm on mute.
Yeah.
Can you hear me
Okay.
now?
We can hear you.
Oh, good.
Yes, we can hear you now. So please start over.
I'll start again by, first of all, saying thank you to the organizers and to Anne for the question. And so my proposal, I was suggesting to look at some of the case numbers, the statistics by arbitral institutions to compare what has happened during the pandemic as to compared in previous years. Now, I need to give you maybe one important caveat when I do this, and this is, as always, when you look at statistics, is that it's not an easy box ticking exercise, but it actually involves some interpretation. And therefore, the answers are not as straightforward as one would wish. And in particular here, of course, we don't have the baseline but for analysis. If we look at 2020, we have the figures with the pandemic, but what we don't have is the figures without the pandemic. So the best we can compare it to is the previous year, that is 2019, prior to the pandemic, to the extent it was prior to the pandemic. But we don't have a clear but for data, i.e. what would the world have looked like without the pandemic. So with that caveat in mind, what do we see if we look at arbitral institution statistics? The first thing we see is that 2020 has been actually an excellent year when it comes to case numbers overall. Many arbitral institutions have reported record-breaking case numbers overall. So the ICC, for instance, reported in 2020 a higher case load compared to 2019. So did the LCIA, actually reporting an all-time high of cases, up 18% from the previous year. And probably the biggest rise was seen in SIAC, in the Singapore center, with over 1,000 new case files, which was a 125% increase from the previous year. So I could go on like this. There are, of course, other institutions. I'm happy to say that for the Brazilian Center of Arbitration and Mediation, you will be aware that the 2020 data is not officially been released yet, but I have been given by the institution some figures to report informally, and the cases in 2020 have also gone up 8%, and 2021 is actually on course to be also a record-breaking year again. So what do we see here is that there is an increase in cases, and that is indeed rather plausible in the sense that the pandemic, of course, has caused disruption to a lot of contracts, and disruption means dispute. So once again, if you're a dispute resolution lawyer, it's always a bit sort of counter-cyclical. When other economies are down, the dispute side is often up. The second element I would like to report, looking at the statistics, is institutions that have features like emergency arbitrators, expedited constitution of tribunals, or expedited procedures as a whole, that these features have also seen a sharp rise in the 2020 numbers. And again, this makes sense if you think about it, that the COVID types of questions of disruption of supply chains internationally often require a very quick resolution of disputes. Now, you'll probably ask yourself, what about different industry sectors? What are the industry sectors that are most affected by COVID? And you would probably think of transportation, you would probably think of sales of goods and supply chains in particular. Now here, I'm afraid the picture I see when I look at the statistics is not as clear. In some cases, institutions have reported an increase in industry sectors and can track it down to COVID. For instance, the LCIA has said that in the hospitality and leisure sector, sports and entertainment, they can see that there is an increase in those industries, and that is actually related to COVID. In other cases, it is more nuanced. Energy, infrastructure, construction, the sort of normally high points in any institutional caseload have actually seen very little variance, so they have remained stable on a very high level. And then regarding other industry sectors, sales of goods, for instance, some institutions have an increase, some institutions have a decrease, so you can't really say anything meaningfully regarding the overall picture. And that is also due to the fact that it is sometimes actually rather complicated to compare statistics from different institutions because they don't necessarily have the same definition when it comes to different industry sectors. Now, my last point, I'm gonna zoom in a little bit more detail in the LCAA case report. And that is not because I have an institutional link to the LCAA as vice president of the court, but rather because I think, as far as I'm aware, it is the case report that has most detailed analysis when it comes to COVID-related cases. So what the LCAA has done is has actually looked at the documents available to the institution, request for arbitration and answer, and tracked down whether COVID was specifically mentioned as a triggering factor for the dispute, and has said that there are quite a few of those cases, in particular, as I just mentioned, in the sort of entertainment and sports events. They've also commented that whenever COVID was a triggering factor, very often a force majeure clause was actually cited in the underlying contract, and we will have, I think, the opportunity to discuss force majeure events a little bit more in detail. And then the last point, and I think that's for me really the most interesting, is they have looked at the lag time for disputes. What is the lag time for disputes? It's the time between when a contract was entered into and the time when a dispute arose. So let's say you enter into a contract in 2000 and the dispute arises in 2005. And that is indeed 5 years is the statistically typical lag time for disputes in LCAA cases. But in 2020, that lag time was shorter, and it was typically that the requests for arbitrations in 2020 were based on contracts only entered into 2018 and 2019, so only a year or two before. And that you can see as an interpretation that a lot of those cases were triggered by external factors, such as the COVID pandemic, as opposed to what would normally be the reason for disputes. So that is, in short, some of the information you can gather from the institutional statistics that I have looked at regarding the impact COVID-19 had on our case numbers as a whole.
Well, thank you, Maxi. That's absolutely fascinating that you were able to digest the numbers and give those to us in such a cogent form. Thank you. Victoria, do you have anything you might want to add to this particular point?
Yes, thank you so much, Anne. And I think that Maxi's comments really underscored how the institutions were able to adapt to change rapidly, which is fantastic. Another aspect that I think institutions have adapted to very well is that reduced travel and reduced paper document printing during the pandemic had a significant impact on arbitral institution practice, as well as a significant impact on climate change. This underscores the work of the Campaign for Greener Arbitrations. For those of you who may not have heard of this initiative, the Campaign for Greener Arbitrations is an initiative to reduce the environmental impact of international arbitrations. And it was founded in 2019 by Lucy Greenwood before the pandemic. But certainly the work of the campaign has been accelerated by the pandemic and also by the climate change emergency. I am on the North America Steering Committee, and we are hard at work on trying to bring stakeholders into the conversation to reduce the carbon footprint of international arbitrations through behavioral change. So the question is, after this pandemic finally ends, will we continue to travel less for arbitrations and for arbitration conferences like this one than we have in the past? Will we have more virtual congresses like the one we're having now? Will the move to digital documents last, or will we go back to paper bundles, for example? Will virtual hearings become the norm? due to their cost and time effectiveness? Or is there really no substitute for the in-person, tangible arbitration experience? These are questions that we still have not yet answered, but we will certainly see in the near future what will happen. I think institutions have had to be nimble, and I'm sure they will have to continue to be nimble as the situation evolves. But I do predict that many of these digital changes to arbitral practice are here to stay. Thanks.
Well, thank you. And of course, none of us have a crystal ball, so all of this is supposition on our part, but I would certainly put of your thoughts and those of Maxi's as being probably the way the future in terms of arbitration. Mohamed, I'd like to turn to you for a moment. Your co-panelists have been able to share their thoughts on what effects the pandemic has had on arbitration. And I'd like to pose a slightly different question to you. Will we witness new streams of business, contracts, and related disputes in a post-COVID world? If so, in what areas and in what way?
Thank you very much, Anne. I've been very much enjoying the great contributions and insights by my colleagues, and I hope I'm being heard. If so, but anyway,
you are.
Thank you. So yes, I mean, it's a very interesting question. Let me tackle it from both ways. Now, the short answer is yes, we will be witnessing new streams of disputes and even new sectors challenging slightly the dominance of the traditional all-time favorites. Let me tell you briefly the following. I mean, we all know that the all-time favorites include construction and energy, accounting for a very fair percentage of disputes worldwide. But what the pandemic has shown us for these specifically two sectors is that many challenges have arisen and led to streams of disputes. First of all, it has accelerated, whether people liked it or not, the integration of information and communication technologies in construction and energy activities, and in fact, across the board. But it has also presented unprecedented challenges in relation to mobilization of personnel, causing disruption to procurement and supply of equipment and materials in these specifically two sectors, operational constraints, adverse effects on liquidity and cash flow, which has led to an increase in disputes. In insurance, for example, we also see a rise in a new stream of disputes dealing specifically with business interruption and focused on whether COVID-19 is included in the policy and can be covered by insurers. And so the scope and interpretation of policies wording is indeed now at play and in dispute in many countries in the world. Moving into from these new, let's say, from these all-time favorites, in terms of the trends of disputes in relation to, for example, construction, well, of course, the techniques will change. We see that there is more reliance specifically on smart construction contracts, increasing use of drones and robots on work sites, the use of augmented reality and building information BIM application modelings in construction, more remote work site and mobile access. And we see whether in the construction or energy, greater awareness and integration of decarbonization of projects, more greener approach into these activities, and the tendency to move to smart projects, smart communities and cities. So we will definitely see more streams of disputes and new ones due to the integration of artificial intelligence well beyond the traditional information and communication technologies. Now, in relation to new streams of business that we already see a glimpse thereof, biotechnology and pharmaceuticals, we already see that COVID-19 has brought about at the forefront the importance of biotechnology and pharmaceutical activities. And so I think it is destined to continue in these activities, and more disputes are going to arise. And we're going to see a rise and a proliferation of disputes within the biotechnology and pharmaceutical sectors. Fintech is also on the rise. And it's quite interesting when people talk about fintech and the automation and use of technology in finance. We will also see Comtech for construction, Enertech for energy. So I think it is indeed useful to note that. Artificial intelligence related contracts, we now see that there is a lot of attention and developments to integrating artificial intelligence in contracts across the board, not just in relation to traditional type of smart contracts, but integrating it into traditional contracts as well. So I predict that there will be very much a lot of disputes in relation to AI-related agreements. Tourism and leisure is a sector that is normally downplayed in a way, but I think we now see at the forefront of things space travel and trips for leisure and tourism. And I know that Victoria as well has a view that this as well in relation to mining and stuff, which I'm sure she would be able to share some thoughts on. But space travel trips are indeed increasing. And with that, we can see new streams of disputes given the requirements of mental and physical health and how these contracts and trips are going to be organized. So I think there is these types of business activities will be increasing as well. In addition to what Victoria has also hinted to, climate change. Environment is at the forefront of many disputes, and climate change is indeed one of the topics that is at the forefront, and many disputes are destined to deal with climate change. We even see now practitioners expressly saying that they are specialized in climate change. We see firms and boutique firms specializing in climate change and climate change disputes. So these are basically some thoughts about the future and the new stream of disputes that we are, I think, destined to witness over the coming few years.
Thank you very much. You certainly have a crystal ball. Victoria, do you have anything that you'd like to add to what sorts of disputes we may be seeing in the future?
Thank you, Ann, and also thanks to Mohamed for those very thought-provoking comments. I think Mohamed's absolutely right about the areas in which disputes will be on the rise. I'd just like to add one more to his exhaustive list, which is that I predict that the fast-moving legalization of non-lawyer ownership of law firms through entities known as alternative business structures will lead to additional conflicts of interests, disputes over financing and control, and bar disciplinary actions. For those who may not know, alternative business structures are entities that are allowed to practice as law firms, and they are allowed to have non-lawyer owners and managers, such as third-party funders and other non-lawyer entities. They are granted permission to practice law in several common law jurisdictions, such as the United Kingdom and Australia. And actually in the United States, Arizona, where I'm currently sitting, just became the first US state to legalize alternative business structures. Washington, D.C., the District of Columbia, has long allowed them in a limited capacity, but Arizona has sort of completely opened up the floodgates for alternative business structures. And several other states, including California, Florida, Illinois, and Utah, are considering making similar changes. The American Bar Association has also just issued an ethics opinion that says that if you are a attorney licensed in a jurisdiction that does not allow alternative business structures, which is most of the world, most jurisdictions in the world do not allow alternative business structures. The American Bar Association says, nonetheless, you can invest passively in an alternative business structure that is in a jurisdiction that allows them. So this is really interesting because now lawyers will be able to not only practice law, but also invest in other law firms. And so I think all of these will lead to many more conflicts and many more disputes over how law firms practice and how they engage in multi-jurisdictional and multidisciplinary representation of their clients. So thank you.
My goodness, that is very enlightening. I hadn't even heard of that new law in Arizona. Rodrigo, Perhaps you have something you want to add from your jurisdiction, being Brazil, as to this particular question.
Yes, and thank you. It's fascinating. I don't pretend to have a crystal ball, but it's always fascinating to think what's going to happen next. New technologies always bring new ways to do business and generate changes that impact the new disputes that arise. So, and we would see this regardless of the pandemic. What the pandemic did, in a way, was accelerate a number of technological changes for remote meetings, for example, as in this Congress that we're doing, and like Mohamed mentioned, the use of drones in construction and other kinds of technologies. So all this will impact in the new kinds of disputes that will come in the future. The surging disputes we're seeing now is still something about the past. These were contracts that were entered into before the pandemic. As Maxi pointed out, some of them were very recently. And then there was this huge impact of the pandemic. So we see a surge in a number of traditional contracts, take or pay obligations for energy or gas, for example. And suddenly the industry had to stop and it couldn't use the energy or the gas. Or public contracts like concessions and toll roads that the companies expected to have a certain level of traffic that they simply do not have. So, but these are disputes that are happening now, but that have, in a certain way, a lens of the past. We will see from the future is that people are changing some ways they do business. Lawyers are changing the way they draft contracts. No one will draft a force majeure clause or an insurance policy the way they did before. We're looking now at force majeure clauses that many times didn't talk about a pandemic or governmental lockdowns. And of course, the unpredictability of a future pandemic, for example, will be seen very differently if it happens 10 years from now than the COVID-19 is being seen by lawyers and arbitrators in general. So these are some comments that I'd like to make. Thank you.
Well, thank you very much for those, Rodrigo. I'm now going to pose a question to the panel. We all know that lawyers are known for their creativity when devising claims, and many will see the pandemic as an opportunity to test a variety of claims based on the havoc that the pandemic has wrought. We have already heard Rodrigo talk about force majeure briefly. We had Mohamed talk about the fact that there have been business interruption claims been brought under insurance policies. I know for a fact that in my country, the United States, a number of those suits have been brought against insurers based on business interruption provisions, and to my knowledge to date, none have been successful. And I am certain that the audience would be interested in what types of clauses each of you envision litigants may rely upon to either recover damages or to avoid liability due to the pandemic. And so, Maxi, may I please start with you regarding answering that question?
Yes, I shall certainly try. This is a pretty hard question. There's a lot to be said. May I, before I do so, just give you a very sort of preliminary comment on what has just been said by my excellent co-panelists, and I fully agree with Mohamed, Rodrigo, and Victoria that this pandemic has been really a paradigm shift, not only in the way we do arbitration using remote hearings, but also regarding the substance. And I can give you one very concrete example. I had a case recently where the experts were unable due to travel restrictions to actually go on site and do their expert report on a specific thing. Let me call it a thing, given the confidentiality. And so they actually did use pictures and drone techniques remotely, sort of giving directions how to take the pictures and where to fly the drone in order for them to being able to do their expert reports, because they couldn't physically go to the place because of the travel restrictions. And if you think about it, this is a potential use in the future that we can see even after the pandemic. And it does not only affect the procedure of the arbitration, but actually how experts' reports are written. So with that sort of comment on what has been said previously, let me now try to look at the causes and types of doctrines that we see being used if a party's performance is affected by COVID-19. And of course, the first thing, and Rodrigo already said this, is you should look at the contract and see whether there are any force majeure or hardship clauses or anything else. Now, I've seen a number of them in the past month that I've looked at. And I was surprised, actually, to see that some of them did include pandemics as examples of potential force majeure events. The ICC force majeure template, for instance, which is a pre-COVID-19 template, has the word pandemic in it. Now, even if that is the case, if in the list of different things that could be force majeure event, wars, acts of God, terrorists, God knows what, you do find the word pandemic, this is typically not a guarantee that you will also be able to use your force majeure clause in the particular instance. You will typically still have to show that the requirements of the force majeure clause are met, so that the events that are listed are only typically indicative. They're only presumptions, so to speak, of what could constitute a force majeure. And so the requirements that a party affected by COVID-19 would still have to show are met are typically that the event was beyond the reasonable control of the affected party, that it couldn't have been reasonably foreseen at the time of entering into the contract, and that the affected party could not have avoided the effects on the contract performance. Now, let me also again give you a very concrete example of a case in which a force majeure clause has been used. I'm going to be a bit vague again for confidentiality reason, because this is actually based on an actual dispute I see. Imagine an infrastructure project somewhere in a country X around the world. This could be a hydropower station. This could be construction of a metro line. It doesn't really matter. You can pick whatever you'd like. And in this country X, the government has issued a number of policies that include, for instance, international travel restrictions and stay-home orders during the pandemic. Now, the party, the constructor, of course, was affected because the workers in this particular project could not go to the construction site anymore, and therefore there were important delays in this infrastructure project. So the question then the affected party would have to go through, and the questions that typically arise in that scenario, are first, whether at the time of entering into the contract, the COVID-19 pandemic and its effects were reasonably foreseen. Now, most people would say that the pandemic as such was not to be foreseen before 2019. Others say if you actually looked at scientific reports, And if you took into account that we had SARS in 2002, 2004, the swine flu, and other similar diseases, it was only a matter of time to have something like COVID-19 happening. So that is the question of the foreseeability. For contracts that were entered into early 2019, the question then becomes maybe even more difficult, because at that time the pandemic as such already existed, but no one could foresee the scope and the breadth of the pandemic. And so it becomes a more nuanced question. The other point that the parties typically have to go to look at is whether the affected party could have prevented the effects of the pandemic that then led to the non-performance or delay of the performance. So for instance, in my example with the stay-home orders, the answer is typically yes, that the parties could not have reasonably prevented the workers from not working if there are mandatory stay-home orders, unless of course there are some exceptions that one could have applied for. In other situations, it is more nuanced. For instance, if the idea is that the workers should have been hired and brought from a different jurisdiction, and that the travel restrictions only hindered these workers to get to the construction site. In this case, the affected party would have had to show that one couldn't hire new workers, even if they're more expensive locally. So I think it is too early at this stage to sort of draw some general conclusions on these types of force majeure clauses. We maybe can look at some of the case law that has been developed for the 2002-2004 SARS, which is also obviously a COVID a virus. There is case law from China in particular. You will also, speaking of China, you might also be aware that the Chinese Council for the Promotion of International Trade has, in this pandemic, in the COVID-19 pandemic, issued what they called force majeure certificates, where they give a paper that is supposedly proof that a certain business has been affected by policies, governmental policies, to prevent or contain the spread of COVID. Whether or not these certificates will then be actual proof under the governing law remains to be seen. Now, leaving aside these clauses in the contract, there are also emergency valves in the different governing laws of the contract. For instance, in French law, you have a force majeure doctrine, and that kicks in irrespective of the fact whether or not there is a specific clause in the contract. You would have other doctrines such as impossibility, change of circumstances, depending on the various jurisdictions. I'm happy to talk about these in a little bit more detail if you want me to, but I also realize that I have been speaking for some time, so I'll hand it back over to my co-panelists at this stage.
Well, thank you, Maxi, and I'm sure we'd love to hear more about what you have to say, but for the moment, why don't we turn to Mohamed and get his views from the Africa, Middle East region.
Thank you very much, Anne, and thank you very much, Maxi. Very insightful comments. Let me say, for the Africa, Middle East, and I think that's not even an anomaly within the global ecosystem, if I were to call it this way, we do have our fair share of contractual mechanisms. The two comments I would make in the beginning, though, is that one thing that parties need to consider is not just what they ought to include in their contract, which they should obviously carefully consider, but also the scope and limits on party autonomy, if any, under the applicable law. Or not just the law chosen by them, but perhaps a law that claims an overriding mandatory application when it comes to these specific types of mechanisms. So it's pretty much an exercise into conflict of laws and a matter of private international law, but I think definitely the parties have to be conscious of any legal limitations. Secondly, the issue is also subject or lend itself to careful consideration as to the type of jurisdiction and whether it adopts a civil public law dichotomy. I know we traditionally talk about civil common law, but this is a matter that where civil and public law may come into play. I'm saying that because there are jurisdictions within the MENA region or Africa where you have a very strong hold of administrative law concepts that come into play in relation to state contracts when the state is acting as a sovereign power. And in that sense, they have their own doctrines, variants of hardship, like, for example, imprévision, which is something like exceptional circumstances, not necessarily impossibility, but we have two variants, one in a civil law and one in a public law, and it depends on the characterization of the contract. We also have what we can call in English, acts of prince or fait de prince, which is an act by the state, public or private, that impacts the rights or the performance of the contract due to circumstances that may not necessarily be impossible or exceptional, but an intervention by the state, one sort or the other. There are also, we see, for example, in the US, you have the doctrines of impracticability, and I assume you would be the authority and would love to pick your mind on this and what you think in the US context would be. But we see that the parties are increasingly becoming more conscious of what had been dubbed for many years as boilerplate standard terms, and they are revisiting this to provide, as Maxi has said, more clarity as to what is intended, what is required, and how tribunals and courts ought to deal with the myriad of concepts available under the law or under the contract. And they may not be mutually exclusive because, as I mentioned, the overriding mandatory nature of certain types of these concepts or certain streams of these concepts may indeed call into question whether the party's regulation of contractual mechanisms can be overridden by these legal concepts. One final thought on this is that, interestingly, we see now contractual terms dealing with a duty to mitigate. And perhaps that is something new to many, which is basically, it's building on what Maxi has mentioned as to what steps have been taken by a party. Normally, we would look into the law for that, but parties have included sometimes steps that they have dubbed as mitigating factors. So now a duty to mitigate, which was traditionally perceived as a legal duty subject to the applicable law, is now even finding its way creepingly into contracts to becoming one of the contractual rights and obligations that can be invoked by the parties. I will shut up here and I will give you back the floor in case any of our esteemed co-panelists wishes to add other thoughts. Thank you.
I think we would all be very interested in Rodrigo's thoughts, since he is our representative from Brazil on this particular question. Do you have anything you'd like to add on this, Rodrigo?
Yes, thank you, Ann. Well, the kinds of doctrines that we have in Brazil are, we're a civil law country. It ends up being very similar to the doctrines that Mohamed was mentioning. So we have concepts like imprevisions, certain standards for revisions of contracts, the Act of the Prince. All these doctrines are in one way or another applicable under Brazilian law, with certain details depending on the case. We also some concepts have been developed more in the case law, such as the duty to mitigate damages, or certain concepts of frustration of contracts and such. But one thing that I'd like to mention that I find interesting, looking at the COVID cases so far, is that sometimes both the claims and the defenses are very general in terms of the facts of each case, and I think it's very important to analyze the specific facts and the specific ways that the pandemic affected one business. So, for example, if you're a street shop that was obligated to shut down for months or several weeks at least, you had a kind of impact in your business. If you're Amazon selling online, maybe you're selling more than you sold before. If you're a restaurant, you're shut down. If you're a supermarket, you did not, or a drugstore, pharmacy, and maybe you're selling more. So it is very important not to take for granted that the pandemic disrupted everything. Each case is a different case, and we have to look at the specific facts of each case, not only to the applicable law.
You made the comment about Amazon, and I can personally attest that I helped Amazon through the pandemic. I have probably ordered more online in the last 18 months. We all did. We helped them out. And I do want to pick up for a moment on the challenge or question, shall we say, that Mohamed threw my direction, and that was the question of impracticability and how the U.S. courts might look at it. And that's a question that cannot be answered. And the reason it cannot be answered is the following. One, we have 50 different states with different laws, and so it's going to be very factually dependent as to what the law happens to be in that particular state. But then you have to overlay that with that we had no national means or edict regarding how to deal with the pandemic itself. And we had some states in which there were mask mandates and shuttered restaurants, and we had other states in which it was mandated that you weren't supposed to wear a mask. And so as a result, the impact on various businesses is going to be very dependent upon where that business happened to be located. It is not going to be a universal impact, as it may be in some other countries where there were uniform laws across that country. And then you have to overlay that with the idea that each of the states in turn has its own laws and regarding the question of impracticability. So there's not going to be any easy answer to that. I mentioned the fact about the business interruption cases. And in fact, those, for the most part so far, have looked very carefully at the provisions of the insurance agreement itself to make the determination that, in fact, it is not covered under the contracts. And now I'd like to go to another topic, which, Victoria, I know that this is something that you're very interested in, that historically new technologies have emerged. The question of whether proof is authentic has also emerged. For me, a very simple example is when the copy machine was invented, and there was discussions and arguments surrounding whether a copy could properly be admitted as evidence. And of course, today, so-called hard copies are typically admitted into evidence without question. But in this digital age, are we taking authenticity for granted? And if we are, does taking authenticity for granted undermine the arbitral process?
Well, thank you so much, Ann, for that compelling question. The proliferation of virtual hearings and virtual proceedings means that many things are now virtual that we normally would have expected to be live and in person. Therefore, we are having to trust in the authenticity of many aspects of arbitration that we normally would be able to verify with our own five senses. So here are some examples. Digital signatures versus ink signatures. How can we tell whether a digital signature is authentic? Digital images or digital videos of witnesses. These types of presentations can be doctored using Adobe Photoshop, or there's a term called deep fakes, which is where you can make a video where it appears that a person is speaking, but it's purely a fake video. Is it possible that witness testimony can be faked in this way? Is the witness who is testifying virtually also communicating with some unknown person off camera who is coaching them or providing input on their testimony? What about digital documents? We've talked about them a little bit on this panel. How do we know that the text of a digital document has not been modified illegally? If a witness or a party says that they're in a particular geographic location while participating virtually, how do we know whether that is true? Maybe they're sitting on a beach somewhere enjoying a cocktail during the arbitration. What about the identity of the person testifying or appearing? We have sometimes spotty internet connections, challenging internet connections around the world. This may lead to blurry videos or difficult to hear sound or other tricks that someone might try to engage in that may obscure the identity of the person participating, leading to questions about who that person really is. On the other hand, however, will the dispute system fall apart if we do not maintain a default presumption of authenticity? Arbitrators do not have the expertise to verify handwriting or the veracity of digital documents, photos, or videos. Arbitrations will be derailed and will take much more time if every digital aspect must be verified and cross-checked before proceeding. If parties do not trust their counterparties and witnesses to be truthful, then everyone loses faith in the legitimacy of the system. If arbitrators do not trust the parties and the witnesses, how will they be able to identify a version of the truth to stand on when deciding the case and drafting the awards? And then by extension, if the presumption of authenticity is abandoned in arbitration, will courts second guess the validity of arbitration awards? If they do, that would undermine the global success of the New York Convention and other enforcement conventions due to authenticity and legitimacy concerns. So therefore, I conclude that we must continue the broad presumption of authenticity, however fraught it may be.
You know, you raised an interesting point there, Victoria, when you started out with the electronic signature. I actually chaired the ICDR's Rule Revision Committee, and that was one of the things that we actually put into the rules, was that, in fact, it could be done electronically if, in fact, it complied with the various laws that would be applicable. And the reason for that was that there had been some real concerns and difficulties in signing arbitration awards during the pandemic. So turning now to the comments that Victoria has made on this point. Mohamed, do you have anything that you would like to add?
Well, I will simply add the following. I mean, Victoria covered it all, but I mean, indeed, the presumption of authenticity in many legal systems relates also to the burden of proof. If you are challenging authenticity, you carry that burden of proof in a way. So it becomes also a question of the burden of proof. But going, let's say, making a leap of faith and going to the future, I think our whole understanding of authenticity will change, because as a matter of fact, with the integration of artificial intelligence aspects, the perceptions of authenticity and the perceptions even of how to prove that may change. I will say the following: the facts that we now see, by the way, and that's happening, what we call automated agents. These are agents surfing the internet, making offers and potentially acceptance. You'll have contracts concluded without direct intervention of natural persons. You may even, and people, get scared about this, robots being decision makers or neutrals, and some people think that's science fiction, but it is taking place. I mean, for example, the Beijing Internet Court, they are using artificial intelligence and robots to prepare cases and assist people with some decision-making aspects. In addition to that, and finally, I think we all know that when we talk about digital signatures and arbitral awards, whether they can be digitally signed or not, it's a hot topic. In many jurisdictions, still you have to sign hard copies, and in even some jurisdictions, including the MENA region, there are expectations that you would sign every page with ink in that sense. What I predict in the future, especially when it comes to enforcement of awards, is that there will be free electronic circulation. So you won't take the award, print it, and go to court to deposit it for enforcement. There will be, I would predict, at least a convention or some sort of an arrangement where the award would be transmitted electronically across jurisdictions and to courts. And if it's digitally signed, no one needs to hold the paper in hand. it will be digitally transmitted in that context. And that's not science fiction. I see that happening, but we will just have to wait and see how we will deal with all these aspects that will bring about their own new version of disputes and their own new version of what we call authentic versus the traditional meaning that we ascribe to authenticity.
Well, thank you. Rodrigo, how about you? What is your thoughts on this authenticity question?
Thank you, Anne. I think this is a fascinating question, but in a sense, it is something that's not really new. Maybe have another thing that's been accelerated by the pandemic, but it's something that has to do with the evolution of technology. We were raised, all of us were raised in a paper world, and we're moving to a digital world. So it has a lot to do with perception, as Mohamed said. We are used to having paper bank statements, for example. They virtually don't exist anymore. You look at your statements online. You used to travel with paper airline tickets with 3 carbon copies. Now you have your boarding pass on your cell phone. So it really has to do with the way we perceive things to be legitimate. And at the end of the day, as Mohamed also mentioned, it is an issue of burden of proof. If someone has an issue with the authenticity of a certain document, it has to at least show that there is some indication that it might not be authentic. So the fact that we're now submitting documents through SharePoint files is not very different than sending them through pen drives before, or through hard photocopies. It's really, I really believe it's an issue of perception, and that it's going to evolve as time goes by, and we're end up being used to things that we thought were a little weird.
Okay, thank you on that. And you're absolutely right. I went to take my first flight in 18 months, and it was very interesting how different the airport was, and how you had to hang on to your telephone, and it was basically your key to do everything at the airport. Maxi, do you have any comments you'd like to make on this authenticity issue?
Very little, because everything has already been very well put by my co-panelists. I think the fascinating thing by this is that Victoria has showed us how the advance in technology, and particularly with the remote hearings, has led to a number of authenticity questions. But at the same time, I think we've also heard from Rodrigo and Mohamed that the advance of technology can also partly solve those questions. So, for instance, the question of authenticity of witnesses. To what extent do we actually believe a witness is indeed
Yes, Maxi froze.
that institutional rules like the ICDR or the LCAA actually do allow electronic signatures, but that we do have technological solutions that permit us to have an authenticated copy located somewhere. Public notaries in Europe these days allow electronic signatures. There is no reason why we couldn't be doing the same for awards. And then my final comment maybe is that we should also keep in mind that during the pandemic, we were in a situation where remote hearings were held in a somewhat strange setting where every single person was in front of a camera, often at home, not in their offices. But my prediction is that these remote hearings are here to stay, but not necessarily in this full-fledged remote format, but rather in a hybrid format where, for instance, claimants counsel gather in the law firm together, respondents counsel do the same, the arbitrators potentially even sit together in one place or connect individually. And in doing that, also some of the authenticity questions will be reduced. Some others will arise on top of the ones that Victoria has mentioned. But I think, as I said, there are technical solutions to most of them that we need to be tackling in the time to come.
Thank you, Maxi. Victoria, you've now heard what your co-panelists have said about your initial comments. Is there anything you'd like to add?
Yes, thank you, Ann, and thank you to all of my co-panelists for this rousing discussion. I just wanted to highlight a few things that everyone mentioned. Mohamed and Rodrigo highlighted the question of expectations, the change in how we are practicing arbitration as a result of the pandemic and as a result of also trying to get out ahead of climate change, change our expectations regarding what is required in order to prove facts, in order to prove authenticity and legitimacy. And I think that as we move further into this great digital frontier, our expectations will change even further. And to highlight a point that Mohamed made about the AI getting more involved in dispute resolution than it already is, I think there's a larger question too about the humanity of the process. I mean, arbitration is older than our institutions. It's older than our rules. It's one of the fundamental human methods of dispute settlement. If we go back to thousands and thousands of years ago, when disputes were settled by elders in the community, that was a form of arbitration. And so it's fundamentally a human form of dispute resolution. And so I think that, as Maxi mentioned as well, having everyone gather together in a room as co-counsel to sort of think through strategy, that's part of the human element. And we have to be careful that we don't lose the human elements of arbitration as we allow more technology, more artificial intelligence, more robots to help us. We need to make sure that they don't sort of take over the process. Of course, not assuming that in science fiction terms the robots are going to sort of dominate humanity, but just in the sense that the human touch and the human elements of dispute settlement need to remain at the forefront, even as we integrate these technological advancements. Thanks.
Thank you, Victoria. I had started at the very beginning asking the audience to provide us with questions. And Victoria, I'm going to put you on the spot first because your authenticity comments has raised a question. And it is, don't we take the authenticity of in-person hard copy procedures for granted as well? Witnesses may lie or even put someone else to testify on their behalf. Documents may be falsely signed and case files altered or burned. What's the difference from this to its digital counterpoint? Tough question.
It is a tough question. Thank you so much to the audience member for the question. So here's my thought on this. We as human beings have more than just, our speaking, hearing, and seeing. We also have this sort of feeling about us. When you're in the room with another person and you appraise them and sort of think about, is this person, lying to me? Is this person hiding something? We look at things like body language. Sometimes you can just sort of feel another person's anxiety next to you. These are things that we've traditionally relied upon to give us a hint as to whether someone is engaging in deceit. And so that's something that we lose a little bit in the digital environment. I mean, we can sort of see and hear the person, but we don't necessarily feel their aura next to us and feel that anxiety or tension that comes in the room when someone is trying to be untruthful. The other thing that happens, I think, in a circumstance like that is if a person is in the room, a witness is planning to lie, there's other people in the room who know that the witness would be planning to lie. I don't think that it would be a secret from a strategic perspective. And so there may be exchanges of glances or body language or something like that that also gives a clue to the counsel and the tribunal. So when we go into a digital environment, we lose all that because we don't know if there's an unknown person sitting in the room on the other side of the camera. We don't know if there's an earpiece in the ear of the witness that they're listening to as they're testifying. All of those things come into play when you're in a digital environment, whereas when you're in an in-person environment, yes, you won't be able to confirm every document or every witness statement as 100% perfectly the truth, but at least you can get a sense, something's not right here. It feels like someone may be being deceitful. And I think in the digital environment, we lose that. So I do think there is a slightly different element in the digital environment, although you're absolutely right that in the in-person environment, we still had to deal with these challenges.
Thank you, Victoria. Maxi, I have a question that was directed to you as well, and that is it possible to say that we have seen an increase of conflict and arbitration due to the pandemic?
Thank you, Anne, for the question, and thanks for the anonymous member of the audience. Can I, with your permission, Anne, just very briefly react to the question that was put to Victoria?
Absolutely, Maxi, please do.
Thank you. I totally agree with what Victoria has said in terms of, remaining humane and being able to maybe read the room as we say. But just to make a counterpoint, there is scientific evidence that we might actually be better in reading witnesses if we are not in person physically in one room. Why? We shouldn't be influenced by the fact that a witness is very charming, extremely nice, good looking, maybe, that we bump into someone at the coffee machine. And of course, no one will openly admit that as a decision maker, we are influenced by these factors. But scientific evidence shows that extraneous factors, unconscious biases, noise, whatever you want to call them, are indeed influencing decision makers. And so cutting those out, having only the person that is witnessing in front of you, seeing that witnesses on a screen, potentially even seeing the whole body of that witness on camera, depending on how your settings are. I usually want to have both, a camera of the room and a camera of the person that is witnessing. To have that and only have the word and the testimony of that witness, arguably, we are actually better at finding out what is authentic and credible witness evidence as opposed to in-person meeting. It's not my scientific evidence. It's actually of psychologists who have looked at this. So I just wanted to make that counterpoint. I think we need to be mindful of these truth strings. Now, coming to the question that was actually put to me, is it possible to say that there is an increase? As I said, it is difficult to read too much into these statistics. I think you can say that 2020 has been a record year for many arbitral institutions. I have seen no case report that went into as much detail as the LCA, the London Court of International Arbitration's case report, that actually looked at the underlying documents, request for arbitration and answer, and by looking into those documents, we're able to say, yes, some of those disputes have actually been triggered by COVID. So here we have clear evidence. But only on the statistical evidence, I think there is a good case for saying that there is an increase in caseload due to the pandemic. But as I said, this is not scientific enough because we don't have the underlying baseline, what we compare it to, which would be 2020 without the pandemic. Maybe SIAC would have equally record-breaking cases, or maybe the Brazilian CAM chamber would have had equally an increase in case numbers. We simply do not know that.
Well, thank you, Maxi. And I would like to go back to what you. Oh, I'm sorry. Go ahead. Yes, please, Rodrigo. Please.
Hey, just a quick comment on what Maxi just said. Another statistic that I think well, I'm sure we don't have, and I don't think we will ever have, is related to the number of settlements, pre-dispute settlements. Talking to friends, other lawyers, I've heard from many cases that were about to go to either court or arbitration, that because of the crisis of the pandemic, the parties were more willing to settle pre-dispute. So this may be also something that we see, that parties may be more willing to negotiate before going to a dispute.
Thank you. If I may, I want to comment. Go ahead, Maxi. Go ahead.
Sorry, it's difficult to sort of have a conversation in this setting, but I totally agree with Rodrigo. And I would add that maybe sometimes even the format of the remote hearings might be a very fruitful source or ground for settlements. Why? At least my experience anecdotally is that because of the fact that a hearing is conducted by video conference, adding additional people is no extra costs. So I see more junior lawyers participating, but I also see more client representatives, party representatives, general counsel participating in procedural meetings, case management conferences, and hearing on the merits. And that participation, my guess, I don't have any statistics here, my guess is might have also been a trigger in some settlements, because they actually get a feel of where the case is going, because they see maybe a tribunal question, or they see how the procedure is going to evolve. And as a tribunal, you are always very happy if you see party representatives being there, so that they get a good sense of what is actually happening in the arbitration. And I will be interested to see whether the data that we will see on settlements might actually show an increase in settlement over the pandemic years, and maybe partly explained by what I've just said.
And I would like to add something to what Maxi said when she was talking about the fact that when you have a witness in a confined space like this, and the extraneous is put aside, that perhaps you can evaluate that witness better without biases that are maybe unconscious. You see this in the United States in jury trials. And in fact, if you are a woman, a lawyer, you are cautioned not to wear your best clothes on the first day, because you're going to be judged as the case goes on by what you have on. And so therefore you're supposed to rank it up as you go along, as opposed to wearing your best clothes the very first day. I've often wished that in the United States we had incorporated what so many other countries have of counsel wearing robes for that very reason, because that is a way to eliminate some of this extraneous noise in the live setting. And of course, as you noted, in the internet setting, you can eliminate some of those extraneous noises. I've got a couple of more questions, and we have a few more minutes here. And this one is was directed to Mohamed. And please, as we have been doing, please jump in if anyone else wants to say anything. And as Maxi noted, it's a bit difficult sometimes to do it in this format, but we shall continue. So let me see if I can find it here. I'm sorry. I'm having difficulty. Here we go. Some companies are choosing to nationalize supply chain. Would that be a problem for international arbitration, and what would be the impact?
Well, that's again a very interesting question, and I think we can spend the whole panel and a day discussing it. But the key word is nationalize. And I think nationalization, expropriation, requisition, confiscation are very interesting terms that lend themselves to a discussion under both international law principles and domestic law concepts. So whether this raises issues and whether international arbitration is dealing with this, the answer to both questions is yes, that is happening. The question is, what will be the outcome or how you deal with that? I think that's a totally different subset of issues that is pretty much dependent on the applicable norms, not just laws, but applicable norms, how the parties dealt with that in their agreements, in their whatever contractual instruments, or governing laws, and at the same time, whether it is given against adequate, just and fair compensation in a timely manner. All these are always questions, all-time favorites before international tribunals when they deal with that. But in a simple, straightforward answer, yes, pretty much the issue is live and is indeed debated and subject to proceedings that have been and are currently being considered by tribunals.
Does anyone else have any comment they'd like to make on this particular point? Well, we still have some more questions. We're not out of questions yet, or time, either one. So Rodrigo, we also have a question for you here. Can we argue that times of uncertainty, such as the pandemic, are both good for developing the law and for boosting the litigation arbitration market?
Well, interesting question. I don't think we should be selfish to the point of thinking the pandemic was good because it caused more disputes. What I really think the pandemic did in terms of disputes in general, both arbitration and courts litigation as well, is to accelerate a lot of things that were probably going to happen anyway. But for example, virtual hearings and the technology was already there, but we weren't used to it. So it probably made us make a leap in a year and a half that would probably take 10 years to take if it wasn't for the pandemic. It has increased the discussion in certain areas of the law that and raised issues that probably wouldn't have been raised if this wasn't for the pandemic. But again, this time it was the pandemic. 30 years ago, it was the fall of communism and the end of the Cold War. 20 years ago, it was 9/11, changing the way we take airplanes everywhere. So each new crisis that comes along prompts new changes and developments. This is just the one we happen to be living right now.
Do any of the co-panelists have anything they'd like to add on this particular point? And hearing no one, I will say that we have now come full circle, because Rodrigo's answer actually takes us back to where we were started, which was the question of what's going to be happening in uncertain times. And I think the one thing that we can take away from this is that there is no certainty as to how this is going to all be handled. We only have ideas. I want to thank all the panelists for their insightful remarks, and I also want to thank the audience for their questions. Unfortunately, we did not have an opportunity to answer all the questions that were posed, and I will tell the panelists we got many questions from the audience, but hopefully we were able to pick some of them that carried on some of the themes that we were able to develop here today. And I thank CAM-CCBC for this opportunity as well, and I thank everyone for their attention and attendance at this conference. Thank you.
Thank you very much.
Thank you. Thanks, everyone. Thanks, Ann. Thanks, CAM-CCBC.
Nós agradecemos os integrantes do segundo painel e assim chegamos ao fim do primeiro dia do 8º Congresso CAM-CCBC de Arbitragem. Lembramos a todos que amanhã as atividades terão início às 9 horas. Nós contamos com a participação de vocês. Até amanhã.